Yes, 21. Yes, what you say? Education. When do you like to have the matter? Next Monday. Okay. 3 ABC Hawk Learned Council for the petitioner submit that instructions are required to be taken as to whether there is any live cause of action in this petition of para based on 12, 11 years. Okay, so uh, higher education, also higher education, 1 week. A mention has been made on behalf of the petitioner for adjournment as there is some bereavement in the family of the learned arguing council. List after a week. Yes, 26 and 27. 26 and 27. There are private respondents on the other side informed. FU board here has that informed or not? On a prayer made on behalf of the petitioner. Matter still adjourned by 1 week. 26, 27. Yes, 52. Somebody is not who is not well. Mr. Noor Mohammed is not well. Other side, okay. Okay, I is for what? Interlocutory application for what purpose? Have you seen the cause list? Have you seen the cause list? There is an I. I is for what? I is filed for what purpose? It is submitted that Sri Noor Mohammed, that Sheikh Noor Mohammed, the learned counsel for the petitioner, is unwell. Sarah, list after a week. 52. 42. What is the matter about? What is the matter about? Okay, we'll have, there is one motion, one, top of the list, one motion, thereafter we'll take. Saikya, see if the microphones are working. Saikya, please Saikya, see the microphones are working. Yeah. On करो लगता है ना? Okay. Yeah. Yes, yes. So the improved order is on page 20, my regarding completion appointment. Ground of rejection is that I did not have the requisite percentage of marks. Last paragraph is in page 20 and except page 20. 20. Yes. Yes. Last paragraph. Whereas after scrutiny of the application submitted, it was observed that the applicant was under qualified with 36% of marks in the higher secondary examination
against the requisite qualification of 50% of marks in the state examination at the time of. My
Hmm.
lordship, I annex the improvement marks, my lordship, on page 14, my lordship.
1-4.
Yes, my lord.
Yes.
It is appeared under improvement scheme, my lord. Nevertheless, my lordship, I may be accommodated to other posts also if improvement marks is not considered.
What is the improvement?
My lordship, after improvement, my lordship, para page para 3, page 5 may be seen, my para 3, page 5. After improvement, my lordship, 55.8%. Para 3, page 5.
63, 59, 58, right. You can appear for an improvement after 12 years.
Yes.
What is the scheme?
Keeping that apart, my lord, regarding that improvement, my lord. Otherwise, also, my lord, 2007 and 12 years already has left, my lord. So, my lord, there's no.
So the consideration was when?
In 2021, my
Consideration was of 2021. It is not on the ground that it was in 2000. But what took you 12 years to go for a betterment?
because 50% marks is required.
No, what took you 12 years to realize?
My lord, the government allowed to appear, allowed me to appear in the improvement scheme, my lord. So I availed that opportunity.
What is your age now?
My lord, my age now 33 years. Earlier also I came before the Honorable High Court, my lordship. I have
You have
only-
filed your affidavit, isn't it?
No, my lord.
No, respondent number 2 has filed the affidavit. Who is respondent number 2? Mr. Laskar, who is 2?
my lordship.
Yes, file. Yes. But consideration is by district level committee or state
My lord.
level committee.
But I have the instruction, my lord, that application form was rejected, cannot be recommended due to late submission of application.
But see the minor switch or the subject matter of challenge at page 20.
Yes, I have done so, my lord.
Your name is Burhan Alam Laskar.
The third page, my lord. Second page.
My second repetition, my lord.
My lord, from 2007 now it's 23, my lord, 16 years. And he could survive for 16 years, my lord.
But when did he apply?
2007, my lord.
When did you apply?
My lord, I applied in the year 2007, my lord. Thereafter I came before the Honorable High Court by filing WPC 60 of 2007, page 18 may be seen.
But that is the second application I have given you, lordship. That is the second application, 21. Applied in 2021.
No, Mr. See, you cannot find fault with delayed submission since it appears that not only an application was filed immediately on time, thereafter writ proceeding was also instituted by the petitioner. That cannot be a reason. And the reason which is you are submitting as per your instructions, handwritten, those are not telling with the reasons which have been put to challenge at page 20. Come to page 20, 20. 20 says that he had secured 36% of marks in HS and against the requisite qualification of 50, and he says that he has got a betterment certificate.
My lord, here it is not clear, my lord. 36 10, my lord, 2007, my lord. And he has obtained 50% in the year 2019. So, my lord, it is not clear, my lord, whether it was earlier considered or not, my lord. So, to that effect, let me get the instruction. So
Let us see your subsequent certificate. Page,
My lord, my lordship, page 14 is the improvement, and page 13 is the original musket, my lordship. The only two, page 13,
page 13 is dated what?
my lordship. 22/5/2007.
And 14 is an examination of 2019.
Yes.
When did you file your application?
I think I have not annexed, my lord.
Not necessary to annex. Come to the impugned order. What is the date of your application?
My lord.
1/7/2018.
Yes.
Was the 19 result out then?
My lordship, before that, my lordship, I came before the Honorable High Court by filing writ petition.
We have understood, Mr. Laskar. You are basing your claim on a betterment mark which is secured in 2019, and your application was considered in 2018. How can you find fault with this?
My lordship, consider me for my qualification.
It has been considered, rejected. Don't come with this kind of litigation. And you should candidly disclose everything. You are saying you don't even know the date of your application. What is this? In an equity court. Heard 3 S.B. Laskar, Senate Counsel for the petition. Also heard 3 Pegu,
my lord, for one, P. Bora for 1, 2, and 5.
Chief Bora, London State Council.
And
For phone numbers 1, State Council, as well as 3 Pegu for the
3 and 4.
for the Elementary Education Department. Considering the facts and circumstances of the case and the issue involved, comma, this petition is taken up for disposal at the admission stage. It may, however, be mentioned that the respondent number 2 has filed an affidavit, and the London Council for the London State Council has also produced certain written instructions for the fact projected is that the father of the petitioner, Faizur Rahman Laskar, died in harness on 3/1/2007 while working as an assistant teacher of Durgapur LP School in the district of Hailakandi. Full stop. The petitioner has stated that he had applied for appointment on compassionate ground on 15/1/2007. Within 12 days of the death of your father, you apply.
I have annexed one additional affidavit also.
You were waiting for your father to die over. Application was ready. That is the compensation you are seeking. You don't even wait for the bereavement period. Is this compassion you are seeking?
But maybe suggested to file the application as early as possible.
You go by his suggestion. Where are we coming to the court?
So maybe he applied.
Now, as a reasonable mind, you ask yourself, somebody close to you in the family has passed away, your father
Yes,
passed away.
Is that-
12 days thereafter you file an application.
Yes.
The case of the petitioner, however, was rejected by the DLC by in the meeting dated 5/10/2021 with the observation that the petitioner was underqualified as he has secured 36% of marks in the higher secondary examination against the requirement of 50%. Full stop. The Sri Laskat Learned Concept has submitted that he had appeared in a betterment examination wherein his marks had improved to 55.8%, and this fact has not been taken into consideration. Full stop. The Learned Council has drawn the attention of this court to the relevant mark sheet. Full stop. Para. The Bora, the Learned State Council, as well as the Pegu, the Learned Council for the department, has submitted in tandem that the rejection has been done on relevant consideration, and in any case, comma, the death being in the year 2007, comma, there would not be any requirement for consideration of the case of the petitioner after more than 2 decades, after about 7 or
16 years.
after about 16 years. After about 16 years. After about 16 years. Full stop. Para. This court has considered the rival submission. Full stop. The case of the petitioner has been structured that the marks obtained in the betterment examination has not been considered, which according to him is meets the eligibility criteria. However, comma, a close scrutiny of the impugned order would reveal that the application which was taken up for consideration was filed on 1/7/2018, whereas the betterment examination is of the year 2019. Therefore, it appears that the entire projection made by the petitioner and the grounds of challenge that betterment marks ought to have been considered is without any basis. This court is further of the opinion that after 16 years, comma, consideration of a case for appointment on compassionate ground may not be in consonance with the objective and purpose of the scheme, which is to provide immediate succor to a family which has lost its only earning member, who was a government servant. In view of the above, yes, next.
Deeply obliged. Maybe Passover for thanking.
This how is it bench? This has come to this court bench format. It is a bench format. It will go before the appropriate bench. It appears that the subject matter pertains to bench, civil bench court, registry to verify and register for the appropriate.
As per the order 12/4/2023, the principal secretary was involved here is an agreement, memorandum of understanding entered into between three parties, State of Assam, BTC, and the NTPC for construction of an ITI institute and subsequent appointment of or filling out the post in consultation with the State of Assam. If I may take your lordship to the order passed by this honorable court.
Just a minute. Who were directed to appear personally?
Lordship, may I kindly see the last page, Lordship? He was the then Principal Secretary of BTC, Lordship.
Okay.
Lordship, may I report that?
No, no, 2 and 3. Who is 3?
2 and 3. Lordship,
When did he go out of station? First of
1st of June, Lordship, his daughter's execution at Italy, Lordship. I have filed a petition. Kindly peruse my affidavit, Lordship. And
this order is of 12/4/2023.
Lordship already pre-settled for her daughter's execution.
Where has he gone?
Lordship,
Where?
Italy. And Lordship, another Lordship, he has to attend a seminar on peak mission, Lordship, at Denmark, Lordship, for Bottleland, etc. Kindly peruse my affidavit in
That will be more important than the court order.
Lordship.
Personal matter, we are not commenting anything. Some official matter will be more important than this court
No,
matter.
Lord, that is not Lordship, but this daughter.
Then why are you coming up with this kind of excuses?
Lordship,
You
daughter-
suppose that we'll accept these excuses.
And, kindly fix the date after 9 days.
Next day he'll have some marriage. Thereafter a shard ceremony. What is this, madam? You want something else to be done? We can secure his presence by taking course of law. We issue a warrant against him.
Lordship, you will definitely present on the Friday dispense for today itself, only today, Lordship. You will present
12/4/2023. The order was passed. It was not passed yesterday. Where is your affidavit?
Lordship, filed on 3rd June, Lordship.
Where have you stated?
Paragraph 2, Lordship. The deponent Bhaktu said that her order dated 12/4/2020, the Honorable Board directed to the deponent to be personally present before the Honorable Court on 7/6/2020. In this regard, deponent most humbly Bhaktu said that he needs to accompany his elder daughter, Ms. Mahek Goel, to Milan, Italy. Ms. Mahek Goel has got admitted into Masters of Design course in Milan. And the course will be start from 7th.
Okay, he'll appear after 18th. Yes, what is your case?
Lordship, on perusal of records, Lordship, I found, Lordship, initially there was only one respondent in the contempt petition, Lordship, and one IAU was filed, W222/2022, Lordship, that
Right.
was disposed of on 4/2/2022, Lordship. In that IA, Lordship, my client was impleaded as respondent number 2, Lordship. But Lordship, I found, Lordship, in the contempt case, notice was never issued to me. So I never came to know that one such case is pending against me, Lordship. And Lordship, I was impleaded on 4/2/2022.
Mr. Biswa, where is the notice? By which order notice was issued to him?
It was implemented after a transfer of respondent number 1.
That we have understood. It was implemented on 4/2/2022, right?
Yes, sir.
And thereafter, after implement, it was notice issued on 4/2.
I need to take instruction.
So note of instructions. Client will not say when which day notice has been issued.
No, not my learned colleague. But he has been regular.
It appears we on 4/2/2021.
2022 lot.
Yes.
IA.
No, that IA we have seen. 4/2 you have said.
And in the main case lordship,
True.
lordship will see after 4/2/2022 lordship, next day was 6/4/2022.
Yes, 6/4/2022. You are directly accept. Did you accept?
That was in respect of the subsequent incumbent lordship.
Hmm?
Another IU was filed on 4/3/2022 lordship. That is for the subsequent incumbent. And I was transferred out of BTC lordship on 14/2/2022. That is only after 10 days of implement. So probably that reason, for that reason,
One
lordship,
second. We'll clarify. Yes, so what is your name? You are presently posted as what?
And Commissioner Executive Reform.
You are not connected to the BTC right now.
No, I'm not.
At that time, you are the principal secretary.
I was the 13th of February transport of
13th of you are now principal secretary.
I'm not. I'm
No.
Commissioner and Secretary Administrative Reform at
You were in the BTC till when?
I was transferred out 14th of February
14 to 20,
2020.
2022. Oh, that means the implement was done on 4/2.
lordship.
And 10 days thereafter, he was transferred. And so far as Mr. Goyal is concerned, is he still the principal secretary?
Yes, my lord. He is presently the principal.
28.
His implement took place on 28/4/2022 lordship.
Have you stated this on an affidavit?
Lordship, affidavit I have not yet filed because
You file an affidavit. You will dispense your personal affidavit.
Lord.
And Mr. Goyal needs to appear. We'll fix a date after 18. We'll have the explanation and ask him to come prepared. Come prepared with the explanation. What are the steps taken for compliance of the order? It is up to you to pursue. Only because the appeal has been filed, we are not going to stay a contempt. You get a stay order from the appellate court.
Appeal has been filed after delay of 4 days.
So, mere filing of appeal is not there is pursuant to the order dated 12/4/2023, Sri Shantanu P. Bhutmare, who is presently the Commissioner and Secretary, Administration Reforms and Training, Government of Assam, has appeared in person. As regards the respondent number 3, whose personal appearance was also directed from MS R.B. Bora, Learned Counsel, has submitted that the state incumbent is presently out of the country in connection with some admission purpose of his daughter at Italy. Sarah. The Gotmare has, however, submitted that he was impeded in person by an order dated 4/2/2022 passed by this court in IA Civil 222 of 2022, and immediately thereafter, on 14/2/2022, he was transferred from the post of Principal Secretary, Boroland Territorial Council, to the present post which he is holding. He further submits that at no point of time any notice about this proceeding was served upon him, and he was not, and a consequence, he was not aware of the proceeding. The state officer, however, is directed to file an affidavit stating these facts on record, putting these facts on record. Full stop. His personal appearance is also dispensed with for the present. Full stop. Para. So far as response number 3, Sri Anurag Goyal, the present Principal Secretary, Boroland Territorial Council is concerned, comma, considering the reasons assigned, as well as the seriousness of the matter involved, comma, the personal appearance is not dispensed with, but only deferred to the next date, to a next date, to a date to be, to the next date. This on after 18th years when on 23rd of June, 23rd of June, 2023. In the meantime, comma, Sri Gotmare, the affidavit directed to be filed. No, Sri Gotmare shall file the affidavit as directed above.
Obligement.
My lord, in item number 3, my lord, we have the instruction, and item number 4, we have filed our affidavit.
Both are connected.
Yes, my lord. Only subject is different. Item 3 for the subject banking, and item 4 for the subject history.
The disciplines are different.
Yes.
Different disciplines. Okay, what is the issue involved? Issue is identical.
Yes, my lord. My lord, there is regarding feasibility report. My lord, at the time of sending feasibility report to the government, my lord, by the council,
We take it for disposal. Are you prepared?
Against this fellow, there are a large number of communications with the council to issue feasibility certificate. They did not do. On that count, our provincialized post was withdrawn. So we are receiving salaries after provincialization after long service. Then suddenly it was withdrawn. On the ground that there is no feasibility certificate. This is their job. They have not done their job, but we are the ultimate sufferer.
Now let us have it for disposal. we can proceed on the basis of one affidavit?
Yes.
Then it will be similar,
Yes, same.
and the other you have said instructions are there.
Instruction, same.
Which petition?
Today, Lord Kumar, dispose of it.
Huh?
No, you have no objection.
15 matter.
Yes, very minor matter.
No, 15 matter. 2015 matter.
No, no. That
Now, if you
I-
have some difficulty, we'll have the later,
in,
but not long adjournment. If you have some difficulty today,
no, I have no difficulty.
then we'll take it.
Lord, first,
Which one?
item number 3,
Name,
Rup Jyoti Bora, actually what is dead. And
Ajit Bora and Ranjit Bora.
her own brother, she was unmarried. So after her death, her two brothers became the party by dint of an IA, which was allowed by the Honorable High Court. Now, Lordship, kindly see my provincialized order. Provincialized order of Jyoti Bora, that
Just a minute.
may be seen page 24.
Just a minute. You are taking 746.
Yes, 740. First, your Lordship, kindly see page 15, my appointment letter.
Page
15.
first, just in 2 minutes, give the background of the issue.
So this matter, on 1/8/2000, I was appointed as the lecturer in banking department at the Kohapur Higher Secondary
The original petitioner.
Yes.
1/8,
on 1/8/2000
petitioner appointed
as lecturer banking and management, basically banking.
at the Kampur.
Kohapur Higher Secondary School, the district of Sonitpur.
Yes.
Then, my
Yes.
lord, permission to Kohapur Higher Secondary was given on 3/9/97, that is just 16. 16.
3997. Permission by whom?
Permission by the council. Here, Lordship would see
High Secondary Council.
uh, feasibility report for upgradation of high school to higher secondary school.
Page
Page 16. And my school's name is page 19, may be seen, page 19, serial number 37.
This is 3797, not 39. 39 or 37. 37. This is not permission.
Yes.
This is
The name of Kohapur Higher Secondary School is at page 19, serial number 37. The contents of the letter may be seen page 16. It is issued from Secretary Assam Higher State Executive Council to the Secretary to the Government of Assam. So they are communicating between, these are the interdepartmental communication between the
one
two
second.
authorities.
One second. Your name is page 19.
Page 19, serial number 30. Name of the school, Kaupur High School,
19 is serial number 37.
37.
Yes.
To understand this, Lordship may kindly come to page 16 again.
Yes, we have read.
So, a feasibility report was done to upgrade the high school to higher secondary school.
Recommendation was made by the committee
Yes.
subject to a feasibility report.
Yes.
Understood. Thereafter,
Then, my lord, the authorities kept total silent about this. In the meanwhile, my lord,
this
the-
feasibility report was sought for whom? From the
top of this
department.
98
from-
high school
Okay.
who are sought to be upgraded to higher secondary school. Now, in the meantime, my lord, may kindly see page 24. That is the provincialization order.
Hmm.
It is with effect from 1/1/2013, but order was passed on 2/9/2013.
Uh, 590 numbers of teaching and non-teaching
And the serial number 9, the lecturer's name is Drupjiti Bora. Serial number 9, page 24.
Gopur Higher Secondary School.
Yes.
That was upgraded.
Upgraded to higher secondary.
And services are following provincialized.
Yes. There were 11 lecturers. Among them, my name is at serial number 9.
Original petitioner at 9, serial 9.
Yes.
Okay.
That was done. Thereafter, this pronunciation order was passed by Director Secondary Education. Then, my lord, a letter was issued to me by the disciplinary authority come Director Secondary Education. Same authority issued a letter to me, that is maybe in page 26.
Yes.
So here he said, kindly see the bottom. You should submit your written statement in defense within 10 days from the date of receipt of this communication, provided you do not intend to inspect the documents which have relevance with the issues under inquiry. In case you intend to inspect those documents, so that was issued. Then, my lord, statement of allegations were also made, and I submitted my reply, that may be seen page 28.
The main allegation is that so far as your subject was concerned,
Yes.
there was no feasibility
Yes.
report.
That is the main fact. Now, I reply, that is page 28.
21/7.
28.
That is 21/7.
Yes, 21. That is 21/7/14.
Yes.
Here I stated everything in detail, and I also stated that managing committee has sent all this information to the Assam Higher Education Council through principal of the higher standard. So those things are there, and principal has also filed affidavit in my favor that yes, he did work and everything was communicated. That is on record. So that thing I am coming later on. Thereafter, my lord.
One. Yes, what happened thereafter?
Thereafter, the improved order was passed. That is page 33, annexure 6. The court order, the service is Srimati Rupjyoti Bora, subject is banking, whose service was provincialized along with the staff of Gopur Higher Secondary School under Sonipur district. Height of this office order number so dated 2/9/2013 with effect from 1/1/2013 is hereby withdrawn until further orders he shall not be entitled to any salary to the post which is hence withdrawn. Now, this simple order is silent about my reply.
Okay. Yes.
Totally set. Then I wrote a letter to the director through the secretary managing committee of Gopur Higher Secondary School, that may be seen my lord. That is the principal. It is important my lord, page 34. Proposal number 1. Today on 18/7/2014, a meeting of the School Management and Development Committee is held in the office of the principal at about 1 p.m. and discussed in details in regard of proposed notice issued by director to the subject teacher, namely Sri Rupjyoti Bora. All documents of Sri Rupjyoti Bora, subject teacher in banking, issued by the school management committee at the time of answer on 1/7/2000 are inspected in the meeting and unanimously decided as follows. It comes to our knowledge from the so-called notice that the founder school management committee appointed Sri Rupjyoti Bora as subject teacher in banking without the approval of Assam Higher Secondary Education Council, and therefore you are requested to continue him in the said subject for his continuous service of 15 years. Or a proposal is adopted in today's meeting to appoint him in the approved subject commercial arithmetic to forward to the director for taking necessary action. So there is alternative proposal also was there. Then Lordship may kindly see page 36. It was issued by Deputy Secretary of the Government of Assam to the Secretary Assam Higher Secondary Education Council regarding inclusion of subject in feasibility report. In sending herewith a petition received from all Assam left out subject teachers association Guwahati on the subject mentioned above, which is self-explanatory. I am directed to request you to take necessary action after taking the matter as per rules and procedures in force. So this letter was written by Deputy Secretary to the Secretary Assam Higher Education Council. The almost same thing is there, page 37. Ma'am. This was also issued by Deputy Secretary to the Secretary Assam Education Council regarding feasibility report. Then, my lord, this minus held among the high dignitaries of the department, and they finally adopted the decision taken, that is page 39 bottom. Page 39 bottom. The Director of Secondary Education stated in some cases, the District Steering Committee have considered the cases where there are government permission to open the higher secondary classes without feasibility report from the Assam Higher Secondary Council. In these cases, they have been issued NOC in place of feasibility report by the Assam Higher Secondary Education Council. In other cases, there are government permission for the school, but one or two subjects were missing in the feasibility report by the Assam Higher Secondary Education Council. The chairman Assam Higher Secondary Education Council stated that after 1999, no feasibility report was issued from the council. On the other hand, the secretary stated that according to government permission, on the basis of feasibility report from council was established procedure. So the institutions or any subject without feasibility report from the council could not be considered for provincialization under the Act. Accordingly, it was decided to consult with the council whether the school subjects having government permission without feasibility report are actually running as per required norms of the council as well as the government. So, my lord, this is dated 29 September 2014. So, it is seen from since earlier there are communications.
That is, communication is 29, it was meeting of 18/9.
It is my lord
Meeting of
29/9/2014.
Meeting is of 18/9.
Meeting was held on 18/9/2014. But before that, 7 July 2014, there were letters issued from the Deputy Secretary. Again, before that, 8/10/2013. So these things were going on,
No,
but the council
7 July, where is 7 July?
7 July page 37.
These are only on the feasibility report. This is the main meeting which was in.
Yes, it was written by Deputy Secretary to the
Now, what is
council.
the subject of 36 to 37?
36, this is 8/10/2013.
Yes, what is the subject?
That is regarding inclusion of subject in feasibility report.
This is a petition which has been received. I'm directed to request to take necessary action after. There is no recommendation. It's only a receipt of a petition. Then come to 37.
37, that is as such,
Request to
requested-
examine. These are only matters to examine. Now, examination has been done on 18/9/2014, which we have shown at page 38. And you have also read the recommendation part. Now, the Higher Secondary Council was directed to be consulted and some information taken whether those teachers are actually performing. What's the last part? Accordingly, decided to consult the council whether the school subjects having government permission without feasibility report are actually running as per required now. That is it.
For that, well, no, my thing is this, but I am a candidate. What are the departmental formalities that I did not know or may not know? But for that, the party petitioner should not be held responsible. So there are communications in between several departmental authorities regarding the issuance of feasibility report in respect of subject of a particular institution. So what language they use, that is not perhaps my concern. My concern is this: I was working, and managing committee before communication has appointed me. I served, and due course of time, my post was provincialized. Thereafter, it was withdrawn suddenly on the ground that there is no feasibility report. But thing is this, fellow, in that impugned order of withdrawn letter, there is no mention that I have submitted the reply. They are not satisfied with my reply. So they did not apply their own mind at the time of withdrawal of my case. No mind was applied. They they technically, I will say, without applying mind, passed the impugned order, and which I got after a long service. Now, in this regard,
Yes, yes.
the affidavit of the principal is very much relevant. Kindly see,
Page.
It was filed on 18/6/15, madam. Principal, that is Sri Dineshwar Bhuya.
Yes, sir.
My lord, may kindly see. Here, para 5 is important.
Paragraph 5.
Para 5. I am reading.
Please.
That as regards the statements made in para 3 of the writ petition filed by the writ petitioner, the same are matter of records, and the deponent does not admit anything which are contrary to and inconsistent with the records. The deponent further begs to state that though in the recommendation of Assam Higher Secondary Education Council filed letter number 3797 to the government for upgradation of Gopur High School into higher secondary school along with other schools, the subject banking has not included, but the service of the writ petitioner was provincialized as subject teacher banking with effect from 1/1/2013 by order dated 2/9/2013. Para 6. As regards the statement made in para 4 of the writ petition filed by the writ petitioner, the deponent begs to state that deponent joined as principal of Gopur Higher Secondary School on 1/8/2011. The deponent submitted the list of teaching and non-teaching staff of the school for the purpose of provisionalization of services, including the name of writ petitioner. This is very important matter. It was submitted on 1/8/2011 as per the provisions of Assam Venture Education Institution Provision of Services Act 2011. The district level scrutiny committee, Sonitpur, after due verification, forwarded the list of teaching and non-teaching staff of the school for the purpose of provincialization of services, and the respondent authority provincialized their services by order dated so and so. So, district scrutiny committee also examined my record and forwarded the same to the state level authority, and thereafter my post along with others were provincialized. Now, Lordship, kindly see para 7 after 4 lines. The deponent further begs to state that the Managing and Development Committee, Gopur Higher Secondary School, Gopur, in its meeting held on 18/7/14, discussed the issue of show cause notice received by the writ petitioner, and after verification of the records of appointment of the writ petitioner, came to a decision that after long 15 years, it has come to the knowledge from the show cause notice that writ petitioner was appointed in banking subject, though the state subject was not approved by the Assam Higher Secondary Education Council, and since the writ petitioner has discharged her duties for a long 15 years in the state subject, therefore requested to maintain her appointment in the state subject, or requested to take necessary steps for appointing her in approved subject commercial arithmetic. Then next page, page 5, para 8 important, that as regards the statements made in para 7 and 8 of the writ petition filed by the writ petitioner, the deponent begs to state that the school authority has no objection in commercializing the service of the writ petitioner as subject teacher in banking or commercial arithmetic. The subject commercial arithmetic is the approved subject of the Gopur Higher Secondary School. The writ petitioner has discharged her duties since the date of her appointment in the school to the satisfaction of all concerned. It may be stated herein that there is no provision of feasibility report for the purpose of provincialization of services of teacher in Assam Venture Education Institution Provision of Services Act 2011. So, my lord, my post was
Yes.
provincialized as per the Act of 2011. And in 2011, there is no provision for feasibility certificate. Only there is a one bar that 1/1/2006. So that was the issue. So in that view, the authority of the higher secondary forwarded my name to the district scrutiny committee. District scrutiny committee, after examining all the relevant records, found me suitable and forwarded my name to the state authority. And in the long run, my post was provincial after serving long 15 years. Now, due to their bureaucratic delay in issuing the feasibility certificate, they cannot take the benefit of their own mistake. In appropriate time, had they taken a step to issue feasibility certificate or report, then this would not have happened. So my submission is this, my lord. The improvement order has been passed very carelessly, without applying mind, and without considering the long service I have rendered for the institution. So it is shocking. It also shocks the mind of the court perhaps. So my humble submission is this: the order of provincialization should be kept as before until her death, who died on 14/11/2017. She died on 14/11/2017, and my higher secondary school was provincialized with effect from 1/1/2013. So this 4 years, for almost 5 years, this service in which should be provided to the present applicant, who are the own brothers of the original petition. That is my humble service.
She was a spinster.
She was not married. So Odit Bora, Ranjit Bora, they are her own brother. And that was their names were included in this case after filing IA. That is IA number 1180, 2018. Two IAs were there. One was for improvement and another was for providing the benefit to them. So this case is a case which shocks the conscience of every man, and the court should raise its arms when there is some inactive nature of works discharged by the state authority. That is the humble prayer that should be provided to the present applicant, who are the ultimate legal heirs of late Dhruv Bora. Original IA through which we became the party, that was 7/02/2018. 7/02/2018.
What is 746? Oh, 746.
746 is the WBC brief petition.
And what is the 1180?
There was some mistake that was corrected.
Original is 702.
There was a mistake in relation, daughter of, and it was the wife of, in that manner. There was some mistake.
Your prayer ultimately is to interfere with the order in 6/1/2015, give the benefit of
From
provincialization,
2013,
which was from
1/1/2013,
2013 till
to
her
14,
death-
11, 2017,
death is
when she
14.
died. Those benefits should be.
Yes. Any case laws you're relying upon?
It's so far this impugn order is concerned, that is arbitrary, that I have said. But
No, case
so for
laws.
the state of the that should be taken wider meaning.
That is your sufficient case laws to support. You are normally equipped with case laws. What has happened today? Normally you come up with citation. We expected that.
Well, kindly allow me tomorrow I will take that case. So for
Tomorrow
item number
yes,
four is
yeah, other one.
Hello?
Other method.
other one, well, it is different. So if you also kindly fix next week, that is only separate matter.
Only the subject is different.
Subject is different, of course, but even then it may kindly be taken next week, and on that day I will submit citation also in that case. In this case, Dhruv Bora, tomorrow I.
No, not tomorrow. We have heard 15 minutes. We'll finish it.
Ah.
When the next meter he is still serving.
Is still serving.
And he wants the service
yes,
benefit.
If, yes, sir, I'm aware with that.
The interim, the impugned order is of same
Interim-
date.
Interim
date.
order is there, and in that case, my lord, one thing is there. Two other similarly situated persons who were working just like me, they have got the relief. Kindly see next item number.
Yes.
So it is the more or less same.
Zero.
Next, my additional affidavit.
The next item is Prafullo Kumar Nath.
Yes, Prafullo Kumar Nath.
Yes.
WBC 260. There is additional affidavit we have filed on 24/8/20. Here, Lordship may kindly say In writ petition, the contents are more or less same. Now, in additional affidavit, I have made certain latest developments in this case, which are very much helpful in deciding my case.
Yes, page,
That kindly see page, my lord, 6 of my additional affidavit. Lordship has six. Has six.
412 to 2010.
For years.
Yes.
No, 4/12/2010
Yes, 2010.
to the Director, Secondary Education Assam, application for permission to introduce the subject history in the institution. Respectively, I beg to inform you that subject history was introduced in Banmukh Higher Secondary School since 1997 as per resolution of the school managing committee dated 2/8/1997. The resolution of the managing committee was communicated to the Assam Higher Secondary Education Council, but unfortunately, it remained pending. Since 1997, history has been taught in the school, and the students are allowed to appear in the examination taking history as a combination of subjects. So, Lordship, here it is clearly shown the council is silent about their function. So the matter is pending since 1997. So that has been communicated by the principal to the council. Then Lordship may kindly see page 7.
Yes.
To the Director of Secondary Education Assam, regarding continuation of service of Sri Prafulla Kumar Nath, subject teacher in history. So this has been written by the principal. Here Lordship would kindly see second para. That's the Banmukh Higher Secondary School was started in 1993 for the greater interest of the public and conveniences of the poor people so that students can study in higher education with the subject English, Assamese, MIL, political science, economics, education, and advanced Assamese. On this ground, the Assam Higher Education Council provided the feasibility report file number so-and-so dated so-and-so. Afterwards, that depending on the need and demand of the student, the subject history was introduced by the Assembly resolution dated 2/8/1997, and Sri Prafulla Kumar Nath was appointed as subject teacher in history. Department since then, the subject history has been teaching continuously with satisfactory result and enrollment. Since his appointment, all government financial assistance was provided to him accordingly. So he also received every source of financial assistance and incentive provided by the government, like other teachers who has the feasibility report. Because earlier there were feasibility report, but only in respect of history that was not there. But this Prafulla Nath received all the financial assistance which were provided to that school, to the teachers of that school. He also received in a similar manner. So that is the letter of principal. Now, on 1/1/2013, the school was provincialized by government letter number so-and-so dated 29/6/2013 with 9 incumbent staff, 7 of them teaching staff and
I
2
think
officials.
we should not mix up both these matters.
My lord?
You are correct. We will not mix up both these matters. This matter has got a different, though ultimately it's the feasibility report, but the background is totally different.
Yes, actually,
We'll complete the first matter, we'll hear him. This matter we can hear it tomorrow or day after. Yes, what do you say?
now here, my lord, one thing,
No, in Prafulla Nath we are not taking up.
no, not that, but Rupjyoti Bora's case here, one thing will be applicable. There are kindly see page 13 of this affidavit. This affidavit, page 13 kindly. Here, some persons were appointed, that is Abdul Hai and Manul Chowdhury. Exactly, they are similarly suited. Page 13.
Yes.
Page 13. This they were the Abdul Hai and Manul Chowdhury vacant at Shidal City Higher Secondary School, and their
Page-
posts were,
Names are not there.
their names are Anju Devi. Lordship, here the names, they filed the case giving reference of this. here Anju Devi and Shiva Bora.
Yes.
They are also same footing. But their posts are not touched by the authority.
Where have you stated?
I will show this. I will show you.
Where have you stated in the affidavit?
That may I am in page 3 kindly. That is mentioned in Abdul Hai and Manulak Chaudhary, page 3, para 5.
Yes.
That two similarly situated subject teachers, namely Abdul Hai and Manulak Chaudhary, who are the subject teachers of political science and education in the Shidol Shuti Higher Secondary School in the district of Bongaigaon, who are appointed in their respective posts on 2899, and some of the posts of that school are provincialized on 3/6/2013, with effect from 1/1/2013, excluding the post of the state teachers on the ground of not having feasibility report from the Assam Higher Secondary Education Council, though their names were sent for provincialization. As such, they filed a writ petition jointly before this Honorable High Court by WC number so, but later on they had withdrawn the state petition on Iman as their grievances were addressed by the authority. They have withdrawn because they got the relief. So
We do not know under what circumstances their cases were considered. Do you have some information regarding this?
no, here I have many prayer.
No,
The
not you.
different tried.
Not you. Not we have asked them.
No, only
We have read that. You don't have that information. We have read that.
they are
Therefore,
not
we are,
providing us. They know.
therefore we are asking him. We are not asking
Yes.
him.
Manulak Chaudhary and
I have
Abdul
no
Hai.
instruction of this.
Manulak
He
Chaudhary
has
and
made a statement that two persons who have been named, they were similarly placed according
Yes.
to him. They had filed writ petition, but in the meantime their grievances were addressed and they had withdrawn the writ petition. Names have been given, but the orders they could not collect. We may ask you to take the instructions
I'll
on
take,
this.
as your lordship is taking up
And,
this matter some other day. So I'll
We
take-
may take it up also. And see, only because somebody else has been considered, per se will not, may not
per se.
mean they have to be on the same footing. So your instructions would be to that effect that whether they were similarly placed that of the petition.
on whether the
But if their
consideration
feasibility, if their consideration was on any other
some other ground than
consideration,
per se.
it may not apply.
even that
But-
WBC may be taken together with this.
That has been withdrawn. That we are not, and put it matter, we are not for it. You take instructions on this role.
Mal.
Yes. Who would like to submit to the first writ petition? First, respondent side.
But your lordship finds that the feasibility report of the schools which were upgraded from high school to high secondary school, page 16.
He appear for the elementary, this higher, higher
This is secondary
secondary
education.
education.
Second.
Page 16,
Page 16.
37.
My lord, the date your lordship will note that 3/7/1997. And page 19, serial number 37 relates to the school my lord, where the petitioner has worked.
Yes, yes.
There were my lord 6 commerce posts where the council gave permission. My lord.
Stream commerce,
6 commerce posts.
stream commerce.
So, stream commerce.
How
For
many?
the six subjects. My lord. Arts 7, 7 science, and 6 commerce. So undisputedly, my lord, the subject banking, where the petitioner was appointed, was there was no permission to that. At the time when he was appointed,
Banking is not here.
banking was there. The subjects are, my lord, bookkeeping, business organization and commercial practice, commercial arithmetic, and elements of statistics, economics. These are the subjects, my lord. So banking undisputedly, well, this is not disputed by the petitioner as well. At the time when he was appointed in 1st August 2000, at that point of time, well, it was a venture school. Government did not have any control over that school. However, my lord, his appointment was to a post which does not have the permission from the Assam Higher Secondary Council.
Yes.
So, my lord, at the time when he was appointed in a post, my lord, where there was no permission. Now, my lord, at 2013, when he was provincialized, my lord, this aspect was escaped by the, my lord, this was not before the authorities, my lord, which the authorities later on came to learn that there were many teachers who in whose subjects the permission was not there. They have been provincialized. And accordingly, my lord, in the meeting held on 18/9/2014, a decision was taken. This regarding the feasibility report, my lord, where it has been constituted that as the feasibility reports are mandatory. In fact, my lord, the definition under the 2011 Act 2Q, it says, my lord, there has to be a permission from the Assam Higher Secondary Council prior to 1/1/2006. In this book, page 647.
647.
647. The earlier act which has been struck down. The definition of venture higher secondary school, Lordship will find at page 650, 2Q.
Two Q.
2Q. Merit. 650. Venture higher secondary school means higher secondary school imparting education up to class 12 and established by the people of the locality on or before 1/1/2006, which has received permission from the state government on or before 1/1/2006, and not provincialized under any act earlier enacted by the state legislature so far, and includes a junior college established by the people of the locality on or before 1/1/2006, which has received concurrence from the government and permission from the Assam Higher Secondary Education Council on or before 1/1/2006.
Yes.
So the permission from the Higher Secondary Council with regard to the subject has to be before 1/1/2006. And in this case, my lord, it is undisputedly till today there is no permission granted to that subject. May I take your lordship to page 38, the minute moment. Page 39, the relevant portion with regard to feasibility.
39.
Page 39.
Yes.
This is a minute of 18/9/2014 prior to the impugn order was passed. May I read it, Madam? Feasibility. The Director of Secondary Education stated in some cases, the District Scrutiny Committee have considered the cases where there are government permission to open higher secondary classes without feasibility report from the Assam Higher Secondary Council. In this case, they have been issued NOC in place of feasibility report by the AHSEC. In other cases, there are government permission for the school, but one or two subjects were missing in the feasibility report by the AHSSC. The chairman AHSSC stated that after 99, no feasibility report was issued from AHSSC. On the other hand, Secretary stated that according to government permission on the basis of a feasibility report from the AHSSC, Mal.
You have just referred to the Act of 2011.
2011,
The definition is that two Q,
650 Mal,
two Q.
2Q.
Let us put the definition again.
Venture Higher Secondary School.
This venture higher secondary school, as the name suggests, is with regard to the school in question.
Right.
It has got nothing to do with the employees or teachers.
Right.
If the case would have been that en masse all the teachers were faced with or were meted out with the same treatment, we would have accepted this submission.
But the school.
Now your submission, it may be a matter of fact that till today, the permission of the council has not been obtained.
Yes, that is admitted.
But you have not taken action against the school as such.
Right.
You have taken action against a particular individual, but not on this ground.
The school, the teachers whose subject had got the concurrence from the AHSSC, those teachers has been provincialized, and those teachers we have not recalled the order. This,
No, understood. But
yes.
this 1/1/2006 deadline is with regard to the school in question.
Yes.
Not for the services rendered by the teachers.
and while granting a permission by the AHSSC to the school, the subjects are mentioned in the feasibility report. What I am trying to submit is, my lord, that 1/1/2006, prior 1/1/2006, the school needs to have a permission from the AHSSC for those subjects the teachers are being appointed.
Do you mean, are you intending to say that permission was taken so far as the other subjects were concerned?
Yes.
The permission was taken
Permission was taken.
from the council.
Yes. That is 1/1/1997. Feasibility report at page 16. 3/7/1997.
And this permission, which is to be there prior to 1/1/2006, did not have the subject of
Banking.
bank. You are in 39.
Page 39.
Yes.
Page 39.
Feasibility report.
Yes, feasibility report. The Director of Secondary Education stated in some cases that the District Scrutiny Committee has considered the cases where there are government permission to open higher secondary classes without feasibility report from the Assam Higher Secondary Council (AHSS). In these cases, there have been issued NOC in place of feasibility report by the AHSS. In other cases, there are government permission for school, but one or two subjects were missing in the feasibility report by the AHSS. The chairman AHSS stated that after 99, no feasibility report was issued from AHSS. On the other hand, the secretary stated that according to the government permission on the basis of feasibility report from the HSSC was established procedure. So the institution or any subject without any feasibility report from the HSSC should not be considered for provincialization under the Act. Accordingly, it was decided to consult with the HSSC whether the school subject having government permission without feasibility report are actually running as per the required norms of HSSC as well as the government. So, this minute, if you'll also find, it's 18/9/2014 is prior to the order of the impute order where the petitioner's provincialization has been recalled. That is of 6 January 2015. So this is the basis, my lord, for which the government has taken for recalling all the provincialization order to those petitioners who did not have, whose subjects were not permitted by the AHS, and the feasibility report did not mention about their subject. So this order, first of all, my lord, has not been felt. The minute has not been felt. The decision based on which the impugn order has been passed. And it is also the admitted case of the petitioner that even after his provincialization, the subject in which he has been provincialized did not have the concurrence. Page 34, he relies on a resolution of the managing committee of the school.
Yes.
Date is 18/7/2014, after provincialization. my lord. And this resolution, the last part, my lord, may I read it? Last paragraph. It comes to our knowledge from the so-called notice that the founder school management committee appointed Rupjyoti Bora as subject teacher in banking without approval of the Assam Higher Secondary Education Council. And therefore, you are requested to continue him the said subject for his continuous service of 15 years, or a proposal is adopted in today's meeting to appoint him in the approved subject. Commercial arithmetic to forward the director for taking necessary steps. Commercial arithmetic was a different subject where permission was there. So this is an admitted position that the managing committee, when he was appointed, did it without the approval of the authority. And that goes, my lord, shows that the appointment of the petitioner at that point of time is without any authority.
Commercial arithmetic was otherwise a subject which was given approval.
Yes.
Yes.
One of the decision of the authorities for cancelling his provincialization on the ground that there was no feasibility report with respect of banking subject, my lord, that has not been disputed. He accepts that position. So there is no wrong on the part of the authority in cancelling the provincialization, having found later on that his provincialization was done wrongly.
Mahmood has drawn the attention of this court to some resolution, some recommendation by the district level committee.
Yes.
Why was it done?
District level, in fact, my lord, the minutes.
In the additional affidavit, I think you have made a statement that even the district level committee has forwarded your recommendation.
Yes.
Under the 2011 Act, my lord,
That is also in the principal evidence.
the procedure under the 2011 Act 12, there was two statutory committees. One, the district level committee. The district level committee will verify the applications received. Once they found that the eligibility is fulfilled, then they will recommend it to the state level committee, and the state level committee approves it and send it to the government for approval. Now, the minutes, my lord, 18/9/2014 refers to that district committee has taken note of certain teachers in favor of whose subject there was no permission, and the mistake was pointed out has taken note of by the committee, and therefore a resolution has been taken that all those teachers whose services were provincialized without a feasibility report is an honest.
Do you have the district level committee's recommendation?
My lord,
This elementary issue of feasibility.
Ma'am.
How was it overlooked by the district level? It is also a high level committee.
Yes.
It is headed by the deputy commissioner.
my lord. Under the 2011 Act, probably
That is in 2011 and seniority is the only requisite.
Deputy Commissioner was the chairman and Inspector of School is the member.
See, these are all objective kind of criteria. Number one, the feasibility report, where the subject was there. Inside the record, so at the utmost admitted that banking was not the subject.
Banking was.
But in spite of that, provincialization was done, taking into account the long period of service time and maybe the need of the student. And he has also made a statement that this particular subject students are allowed to appear in the exam. Yes, anything else?
That's it. Because otherwise, the decision which has been taken by the authority, well, the correctness of that decision has not been disputed by the petitioner.
One clarification.
We will come back to you. We will have a talk. How long it will?
No, but I have the same method as taken by the learned counsel for the elected.
What role do you have?
I know for opening new subject matter, permission is required from the council. Without permission, that subject cannot be included in the feasibility report.
And so far as banking was concerned, was permission taken.
Yes, no, permission not taken.
Otherwise, the decision is not yours. It is the department's decision.
Yes, madam. It's the purview of the
Your role comes in only in the
Sub-
stage of taking permission
permit.
before starting of a particular.
Yes.
Were your representative there in the district level committee?
No.
Or in the state level committee?
No, madam.
You are not those committees. See the act, as per the act. As per the act, is the you have filed affidavit.
My lord, in this case, affidavit not filed, my lord, but the stand taken in affidavit, my lord, in item number 4 is same, my lord. Only the subject is different.
Populona.
Yes.
260. What have you stated there?
My lord, the affidavit, my lord, stated that, my lord, the feasibility report was issued on 3/7/1997, whereas his appointment was made on, my lord, 9/9/1997, my lord, after sending of the feasibility report, where the
One
subject is not was not included.
3/7/97
Yes.
feasibility report.
3/7/1997
Feasibility report.
Yes, ma'am.
And subject introduced.
My lord,
Subject was introduced when?
my lord, it is, my lord, for the subject history, my lord.
And his
For the subject, normally in item number 4, my lord,
understood, but so far as the subject is concerned, banking,
banking is not in the feasibility report.
later on was it introduced?
My lord,
And so far as Papulam Nas, what do you say?
my lord, the same stand, my lord. That subject was also not included in the feasibility.
We can do one thing. Since one affidavit has been relied upon, we can continue this matter tomorrow. And tomorrow you get a chance to reply to the requirements as well as make any fresh arguments on the Papulam Nas case. the facts are slightly different. And you come prepared with some citation, which you normally do. Yes, you have not done research to assist. Why? What are the factors to be taken into consideration? What are the factors not to be taken into consideration? Is it based on relevant factors or are experience considerations taken into account? Come with decisions. What is the decision making process? Where is the scope of interference? After that, heard the MA Mahmood response for the petition. Also heard the cost and secondary whereas DK Roy, where the training council, Assam Higher Secondary Education Council is also present. This for further consideration. Tomorrow. It's completed. Wait, I will hear it. Who are you? Principal. You are supporting. You are not supporting. And for the principal. Tomorrow we will consider your effort. Tomorrow then, not today. So there was some confusion in the last date. We were surprised that councils were different. So we thought that we'll hear it today. This will-
I may be permitted to try to file one affidavit on behalf of management of
16 matter.
Yes.
We finish it today, this side or that side. Since Mr. Biswas is also there, we will have matter. First, are you working?
yes, both are five for
You are also working.
I'm
You said that you are also getting the honorarium.
honorarium and for the last some months it is stopped.
You last time you had said that you are getting the honorarium.
Recently when I taken inspection my but last some months it stopped and
Stop from which year? Which year?
they are saying that for the last some months
Some month, which month?
probably for the last one probably for 1 year. But exactly date they
1 year. And you had said that you
exactly that did not reflect the date my for the last time.
and you
I'm getting regular. No, my T is also stopped my both have been stopped my as per this order. There is an interim order my 24/6/2016 there is an interim order.
he says that he's getting salary.
This is also
Who is for the school?
Yes.
You're for the school.
I am for this school.
No, no, the beneficiary. You're getting salaries or not? No, we are not on that. Are you getting the salaries presently? Current salaries? Working? Yes, department? You're for whom? The money goes from you.
No, your lordship, SSP, your lordship.
It pays the amount.
Permission.
They are the disbursing. They are the person through which the money is paid. You are the authority which pays the money. Are you paying the money? Going to whom? As Biswas or
School also.
as school authority, you are saying
disburse the amount matter.
you are giving to whom?
I am giving to the response number 7. 8. There is
Mr. Fukan, any role of yours? Okay, we will address. What is the case?
There is an interim order on 24/6/2016.
Okay, we will come to the interim order. You tell us what.
So, my lord, what is my humble submit? Let them to file affidavit to clarify or let them to take inspection whether they are receiving on record. Let them they are receiving the honorarium may take on record before.
what they have made a statement, will record it, why instructions record? Up to 2016 matter.
My lord, there is an interim order. How can they appoint that part?
We'll record your interim, your sub. Yes. Tell us, what is the case about?
My lord, kindly say,
Are relying upon any case law?
my lord, to meet up the necessity of an appointment of a second
What is the school in question?
school in Doctrine Lafayette 381 number Doctrine Lafayette LP school.
381.
381
Doctrine
Lafayette LP school.
Lava Shell LP school. Okay. You were engaged
Engagement.
as second assistant cook.
A second,
When?
when my lord, this is by 13/3/2012. By an
Mr.
resolution,
Biswas, have you seen it complete?
page number 11, ma'am.
Page 11.
Page 11.
Petitioner appointed as second assistant cook
Court, my lord. Page 12 is the 11.
at 12. Let us see. By school resolution.
Solution. Pursuant to the departmental guidelines, due to the availability of more than 100 numbers of students for arising the necessity of one second assistant cook, the elderly citizen of the college of the village and loan donator of the school, Sri Hirendra Namasudra, proposed his daughter-in-law's name, Kalpana Namasudra, for the wife of so for the state post, and for his request adopted a resolution unanimously for her appointment. If her post would not be sanctioned, then she cannot claim for any remuneration. The head teacher was handed over to forward this copy to the higher authority for transfer. Accordingly, my lord, I have joined this post page 15, my page 15, 17 to 2012. I joined the this is my joining date.
Yes.
And my lord, staff pattern is prepared. Page 18 and page 19, my lord. It is staff pattern. In page 19, my lord, serial number 219, Kalpana Namasudra. This is my name, my lord.
Half better. Page.
Staff pattern, page 18. Page 18. Three folks, my lord. Anima Namasudra, Shukla Chakravarti. And third one is Kalpana Namasudra. This is me, my
Yes. Three cook.
lord. The second is Kalpana Namasudra. And thereafter, my lord, the remuneration has been sanctioned, my lord, and I received the remuneration. Page 21, my lord. There are some copies. Page
21.
24/9/2014. I received remuneration. 3,000. After page 22, my lord, I received again 900. 9,000. 9 months. These are the some salaries, my lord, I have received at the time. However, certainly, my lord, that I have been continuing in the post. Suddenly, my lord, the SMC, new SMC was constituted, and the new SMC president adopted a resolution, my lord, and saying that then one Palita Namasudra should be replaced in my page 24 and 25. Being a grave pilot, I approached my lord. This honorable court protected him by saying that particular resolution, I have passed the court article 4/6.
Resolution 3. New assembly at which date? Date? 11/7.
11/7/2015.
Palita is respondent 8. So state,
That is paid my lord, 26,920.
this proceeding,
So that
In this case?
impaired reservation
in this case,
in this case,
26,9,
26,920.
and you continue to serve.
Continue. Still I am working.
There are no salaries for your 1 year.
Not one some month they are saying that some
Currently, no salary.
current is not
From how much, since when?
since in the last phase of 2020.
2022. Yes. That's all. Yes. Department, anything? No. Any role? Department? SSA. SSA. This appointment of who? Dr. Bass. By a full manager. Okay. Yes, full management.
Madam, point the issue of the enhancement of the student number, madam. So there was a proposal was given to the CEO that we want another accommodation of another cook. Accordingly, this it is found that this Kalpana Namasudra, this Pravita, that is response number 8, they have donated the land to the school. Now they have become a very poor of the poor, my lord. They are below poverty line. Then
Proposal.
school authority consider her case.
You had sent the proposal to Block Elementary Education.
Yes.
Initially.
Her prayer was considered and she was appointed as a second cook. And it depends upon the financial grant we get. It given
No,
to
no. initially Kalpana was appointed.
He was there. He is still there.
She's still there.
Yeah.
Sir, but you had taken resolution that you are replacing Kalpana by
Second,
Palita.
yes, that is, we have checked, we have in her place, we have brought this,
Now, what was the consideration?
consider the donation of the land.
No, even her father-in-law was a donor.
His father-in-law, her father-in-law has donated the land. So that was the consideration of by the managing committee, that she should get some relief at least, because
No,
she,
both are family members of donors.
I think they are not donors.
Don't am I?
Donor.
Then 50%, 50%, we are the 50% donor. That is the Plavita, response number 8.
No. If you remove somebody, aren't you required to give the opportunity?
Very true, very, that's true. What was the consideration? It is not reflected here.
You-
That's why this is a long delayed matter. That's why I wanted to bring to your plot to notice that what was the consideration. It appears that from the bare reading that a consideration is 50% donation of the land. And her condition of below poverty line.
School managing committee response number
7. If school requires 2 cook, my lord, my prayer that your lordship may give a direction that both should be taken. If there is requirement.
that is up to you, and that is up to the
If we get a
that
get
is
a
up to the guidelines. How many cooks can you have?
what is the financial grant? I do not know. What is the number of students? I do not know at this moment.
Even if there are few number of students more, you cannot have 10 cooks. That is not the idea.
You can have a second one, my lord, if there is a more number of. Okay.
You say responsible 8 is below poverty line.
Yes.
And what about the
I am also below.
is T, T, T. Where? T3. Report of apartment. Yes. You have filed affidavit of opposition. The inquiry was, one-man committee was conducted by which order?
Okay. I
Now, what was the outcome of this report?
I was
Just, no, this report is of 24/6/2016. Removal was of 2015.
I am
That is of 2016. You have already removed. Removal was of 2015. How is that? You cause an inquiry after removal. You remove first, then you inquire. I think your appointment was also not very clean. See the allegations at page 40. Understood. But was it properly done? You come 43 Vishwas, 43 allegation. It is respectfully submitted. Secrecy.
but
What is the last time? No. What is the last time? It doesn't make any sense. The school managing committee passed a resolution copy to the BTO recommending the name of Kalpana Samastra as cook. And
Yeah.
BDO approved the same to appoint Purita Namak. Let us see the warning order. Where is that sign?
Oh, fourth line of
It starts with পরবর্তীতে. Yes. Yes. এবং
block of
yes, এবং তিনি কাজে আমার প্রধান শিক্ষককে where is this translation? It's not
this line is about next line
even the above parts are not correct.
the particular
See, but it emerges that you may have some good reason. Not you, the school management, but school management company, that the appointment of the petitioner was not done from, but to terminate her from the service and appointing the respondent for 8, you need to apply, follow a certain procedure, which does not appear to have been done. There is an inquiry, but that is done after the action was already taken. And there is an interim order, there is no application for vacation. And as per the interim order, we have to presume that this service will give you a liberty. In case you want to take any action, that has to be done in accordance with law. And this order cannot be suspended. Third, we third Chaudhary learned count for the petition. Also heard the A. Focus, understanding of the elementary education department. That not does record education, whereas you are also there for the P section and state council. Repeat MSP does understanding of SSA is also present. The private respondent number 7, which is the SMC
No,
school,
school SMC,
SMC of the school in question is represented by Sri S.P. Biswas, whereas Sri S. Biswas Learned Council has represented Sri respondent by 8. Considering that this matter is pending since the year 2016, the same is taken up for disposal at the admission stage. Having said, the issue involved termination or termination of the services of the petitioner as second assistant cook in the 381 number Dakshin Shahid LP School in the district of Karim. the case of the petitioner that by an appointment order dated 13/3/2012, he was appointed as the second assistant cook in the school question by a resolution by the school managing committee of capital. Pursuant to the state order, the petitioner had joined the post on 17/3/2012. Full stop. Sri Chaudhary, the learned counsel for the petitioner, has drawn the attention of this court to the staff pattern which reflects the name of the petitioner as an assistant cook, and also to the document from which it appears that remuneration / honorarium were also paid to the petitioner. Full stop. Para. Sri Chaudhary submits that the problem arose when a new assembly was done. Full stop. After such constitution, a resolution, the impugned resolution was adopted on 11/5/2015, whereby 11/7/20, whereby the respondent number 8 was appointed by removing the petition. The resolution states that the public in general were aggrieved by the appointment of the petition. Challenging the aforesaid resolution dated 11/7/2015, this petition has been filed. It appears that by an order dated 26/9/2016, while notice of motion was issued, the impugned order dated 11/7/2015 was paid primarily on the ground that the same does not contain any reason. Para. Sri Chaudhary, the learned counsel for the petitioner, submits that apart from the fact that no grounds are discernible for removing her from her service, he was not afforded any reason, any notice or opportunity before such adverse action. He further submits that in terms of interim order passed by the court, the petitioner is serving. Full stop. As regards salaries, he submits that though the salaries were being paid to the petitioner for the last few months, the same has been stopped. MS free second and state council as well as a Hooker Learned Council for the Elementary Education Department submit that the matter is under the SS and they do not have much role in this case. Full stop. MSP the Learned Council SSA has submitted written instructions dated 24/5/2023, along with a copy of the guidelines dated 14/8/2006. She submits that matters pertaining to appointment of cook, etc., are within the domain of the school management, which is to be done as per guidelines. The SCB Senate Council for the School Management Committee, which is response number 7, submit that taking into consideration the increase in the number of students, there was a need for appointment of a second cook, and therefore a resolution was taken and the proposal was sent to the Block Elementary Education BEO, North Karimpet Block. Para defending the impugned action of the Senate Council has submitted that response number 8 belongs to a family of 50% land donors and is and comes from category of BPL. Research has however fairly submitted that from a reading of the resolution of the order, it does not appear that any notice or opportunity was given to the petition. Appearing for the response number 8, 3 as discussed, submit that refuting the allegation made by the petitioner, the state response number 8 has filed an affidavit in opposition dated 15/9/2007. He has referred to the document annexed to the state affidavit in opposition, including a letter dated 24/6/2016, which is a report by a one-man committee. As per he submits that the report would make it clear that the appointment of the petitioner was full of anomalies and was clouded to the extent that the element of forgery could not be fully ruled out. He further submits that the response number 8 is fully eligible for such appointment, whose eligibility has not been questioned in the written. By drawing the attention, and he has also referred to the communication dated 23/4/2016, by which the aforesaid one-man committee was constituted, with the retired BO North Karimpet as the chair. The private submission made by the Senate Council for Department have been duly considered, and the material placed before the board have been carefully examined. The controversy arises with the resolution of the public order dated 11/7/2015. A bare look with the relevant resolution, being resolution number 3, would show that while the response number 8 was appointed in place of the petitioner as the second assistant cook, comma, no notice public opportunity was granted to the petition before such resolution was adopted. Full stop. This an argument has been made on the eligibility of the response number 8 that he belongs to the family of a landowner and comes from the BPL category, comma, the resolution by which the petitioner was appointed dated 33/2022 also takes into consideration that the petitioner comes from a family of landowners. Full stop. Sri Chaudhary, the learned counsel for the petition, also clarifies that the petitioner also belongs to the category of BPL. Full stop. Para. The response number 8 in her affidavit in opposition has tried to defend the imputed action by annexing certain documents from which it appears that an inquiry was held on the appointment of the working of the petition. However, comma, a bare perusal of the documents would indicate that the one-man committee by which such inquiry was held was constituted by a communication dated 23/4/2016 and the report of the committee the report of the committee is dated 24/6/2016. It appears that it clearly appears that inquiry has been done after the impugned action has already been taken in the year 2015. Therefore, comma, the aforesaid facts are wholly irrelevant to the issue to be decided in the said case. Full stop. Para. Even in a case where an inquiry was conducted prior to an adverse action, comma, the minimum requirement of law is to give adequate opportunity to the affected person to make to defend his case, defend his or her case, which apparently has not been done in the present case. That apart, no, para, this court has further noticed that An interim order was passed on 26/9/2016 and till date, there is no application for modification, vacation, alteration of the said interim order. Also, the Chaudhary has clarified that on the strength of such interim order, the petitioner is discharging her duties as the second assistant. In view of the aforesaid facts, this court is of the unhesitated opinion that the dispute resolution of the order dated 11/7/2015 is not sustainable in law, as the same has not passed the scrutiny and has not been passed by following the due process, and according to the same is satisfied. Since the petitioner, since it is submitted that the petitioner has not been paid her salaries for the last few months, the same, the authority, more particularly the school management committee, is to ensure that the salaries are paid regularly. It is, however, made clear that the interference of the dispute resolution is taken only on the facts and circumstances of the case and should be open for the authority to proceed to take any action if any gross anomaly is found with the appointment of the petitioner. But such action is not to be taken by strictly following the procedure prescribed. We'll pass order next week.
Please, Your Lordship. Lordship, in these items, Your Lordship, 6, 7, 8, and 10, Your Lordship, we were supposed to file our affidavits on the last occasion. We have received the signed copies, Your Lordship. Today,
What about 9? What about 9?
9, my lord, instructions are awaited there. I mean, something is supposed to come, but 6, 7, 8, and 10, the affidavits have come, signed affidavit. We'll be filing it during the course of the day.
Then we'll, and when can you,
Sorry, there is standing order. File an affidavit, the procedure adopted, come to the conclusion.
that's okay.
In all cases.
We have those affidavits, but so far as 9 is concerned, when are you filing them?
My lord, that also
Is 9 similar?
my lord, similar only, my lord.
All
Similar.
So we'll do one thing, instead of
That
having
also
it day
some-
after tomorrow, we'll have it after 2 weeks, but in the meantime, you file the affidavit in 9 also.
For 9 also. I'll get mine.
I think that will be okay with you. 3, no, 3F and sending.
Done.
First, you write item number 22. On a prayer made on behalf of the petition, Miss Dr. Ravi.
subject to lordship, opinion.
6, you write. 3F and 6 to 10. 3F and that is Sending Council.
Elementary.
Elementary Department submit that the affidavits in opposition, affidavit as such, in these items except WP 7004/2017 are ready and would be filed. Okay? And would be filed by
I'll
tomorrow.
repeat it.
By tomorrow.
Tomorrow.
So we further submit that so far as WBC 7004/2017 is concerned, comma, instructions have been received and sometime may be granted. File the affidavit. Good. Also heard Sri M.U. Amit, the learned counsel for the petitioners, full para. In the interest of justice, comma, these matters change adjourned to be listed after 2 weeks, along with the affidavit. That along with the affidavit, that may be filed in the meantime.
Subject to your lordship convenience, my lord. Date
One.
may be
Tell us, as agreed to by the parties, please on. Please
Today's
7. So we will have it on 23rd,
23rd.
23rd of June.
proceed, may not be 25, my lord. 22nd, 21 or
21st,
right.
26 will be okay.
then 26th.
26.
No objection.
Deep privilege.
26th.
Obliged.
26th.
I don't see matter a very narrow campus.
Who's there for the department
Higher education.
higher education? Mr. Sharma, you Sharma is not for higher education. You are for higher education, aren't you?
1 second.
What is the matter about?
My lord, the matter pertains to not furnishing of certain inquiry report, subsequently which led to ex parte department process. What has happened, my lord? One focus notice was issued. I will kindly show your lordship only one focus.
Who are you?
My lord, I am the I was the principal of this Villasipara College.
You are the principal.
Yes, my lord. Now I have retired.
Okay, then
Year 20. My lord, there was some incident in the college regarding construction of a college. I was suspended on because thereafter I was again released. I was transferred and posted as principal Bhotia. There I stand. So on there,
thereafter, what is the
thereafter,
grievance?
my lord, during my suspension period,
Hmm.
one focus notice was issued to my lord. Will kindly see page 47.
Okay. Yes.
So lordship will see 27/3/2017. Thereafter, first number
Yes.
one, that while you were working as principal.
Now we'll go in detail. Thereafter, what had happened?
Yes, my lord. My lord, here they have referred to one recommendation by DFI, Director of Financial Inspection, Assam.
Hmm.
This is an external agency where one inquiry was conducted, and based on that inquiry report, they have issued this focus notice, and there are some other reasons for this. My lord, this report was not furnished. Thereafter, after this focus notice was
Where is your reply to this?
my lord, when this focus notice was issued, I wrote a letter to the Director of Higher Education at page 49.
Yes.
I said that I need some documents
Hmm.
relating to these allegations which they have brought to the focus.
Hmm.
Thereafter, no reply was given to me. Thereafter, on 14/12, when I visited the office, I came to know that I thought some time for finding a reply, page 51. Thereafter, your lordship will kindly see page 52.
Hmm.
It gave me this order, page 30, page 52,
Hmm.
13/12/2007. They said that inquiry is already proceeding has been concluded, and they have given me a penalty of 19,69,000 which has to be recovered. Page 56.
Hmm.
page 52, my lord.
This is the order of penalty.
Yes.
Where is the inquiry report?
That has not been given. This was my precise allegation, and based on this allegation, an inquiry order was passed, which stated that no recovery should be. And this same is continuing with it by but not the problem is this petition has died. Now his entire pecuniary benefits, everything has to hold up because of this order. They are saying that since there is an order already pending, so cannot give the petition and all other examples.
Yes.
In fact, they have agreed. In fact, they have agreed that they have not given me the required proof. It was perhaps not sufficient.
Yes, Mr. Das.
But I have filed one additional affidavit, but
Hmm.
uh, disputing their allegation, my lord, regarding no inquiry report was submitted to them, my lord. But, my affidavit is at page 56. It was filed on
Yes.
22nd of May.
Hmm.
My lord, inquiry report was sent to the petitioner, my lord, the address which was available with the school college, madam. And
Return to out of station.
Yes.
Return to source.
yes, my lord.
This is where precisely the entire
Because
problem
that-
has occurred. Because
That was the address which was available to Manoj department, Manoj. That was the address which was available in the Manoj college website, Manoj. The petitioner says that he went to somewhere else. Manoj, that was not known to the department, Manoj.
No, when you were faced with the situation
Yes, Manoj.
where for 7 days he was not there, said to be out of station.
Yes, Manoj.
Thereafter, did you take any further effort, endeavor to serve him an inquiry report?
Regarding that, my lord, I don't have any such a, my lord, that whether any further
Where is the inquiry report? Where is the
inquiry report has been, I think,
where is the second show cause notice? What have you stated in your affidavit? Do you have the record?
Uh,
Let us see the letter by which you had forwarded the inquiry report. And so far as the petitioner's case, projected case is concerned, that he had asked for the report of the fact finding committee. Have you acknowledged receipt of those request letters?
about this actually, the case been dealing by Mr. K. Gogoi, my lord. He's held up in court number 2, my lord. If my lord can
No, records you only need to find whether first whether you had received those letters by which the petitioner had requested for the report of the what is his name?
inquiry report,
No, no,
fact finding.
fact finding. What
Inquiry.
by the DFI. Number one. Number two, we want to see the copy of the letter by which the inquiry report was forwarded.
My lord, kindly pass over the time being, but sometime.
Who will come? We go.
K Gogoi.
Yes, sir. Yes, 30. Yes.
We have been very deeply engaged in this case. It requires some time so that we can reconstruct the file.
Chanda for whom?
I'm for roster number 4 and 5.
Private respondent.
Just,
Preamble,
as per the
Preamble Learned Council submit that they have been recently engaged by the petition to be according to place for some time to reconstruct the file. Correct? Do it. Please, Dr.
First of all,
Next visual. My lord, this is a case when my lord, your lordship get the first my lord observation by order dated 11/1/19. You may kindly go through the note sheet. This is precisely the case. Then the matter was made returnable.
You're referring to which order?
Lordship,
You are referring to which order?
11/1/2019 is your lordship order.
11/1/19.
First order. Your lordship made the observations, my lord, and that is precisely my case. 11/1/2019.
Now who's running the show?
My lord, that your lordship has said, be that as it may, my lord, meanwhile, that private respondent serving for a while, retired, then I was put in as a regular principal, my lord. Then my lord, lordship kindly turned to page 13/5/22 order. 13/5/22 order. Meanwhile, government took time, then again, on this date, matter was taken up.
Yes.
Taken note that regular appointment of the, as you call, lordship got it.
Yes, yes.
It is taken note that the regular appointment of the petitioner in the facts and circumstances present case, including judgment of this court dated so continues to remain, and the petitioner on no occasion appears to have not been continued as principal. However, for a brief period from 21/12 to 31/12/18, another incumbent being respondent number 5, Mitrupapan Bora, was also appointed against the same court. That I challenge, my lord, at that time. Meanwhile, he retired. Respondents intend to undertake a rectification process as may be advisable under the law listed further.
Yes, yes, education.
Yes, education. Then, my lord,
No, no,
kindly
yes, yes. yes,
No,
education.
thereafter, 1 minute. Thereafter, I retired, my lord.
You have retired.
Last April, 22 April, till today, I am not in receipt of a single penny as my pension.
Oh, that's not proper.
And then another date was given, my lord, what you kindly see. Another, on six, lot of occasions they took time. Last order being 28 to 11/22. Have a look, my lord.
Have you filed an additional affidavit?
Nothing,
Have you filed an additional affidavit?
nothing.
No,
We-
you,
Me, we have filed.
regarding bringing this fact into record.
Yes. Additional affidavit dated. Nilikhana.
17 March.
Yes.
2023.
Paragraph 3, my lord. The pension, he has also retired from 34/22. Counsel for respondents apprised the court that they intend to undertake rectification process as may be advisable. 30 state order, so and so short time to apprise the court. But till date, no such rectification has been done.
Yes, yes.
Alright, go ahead, let's file. Then again 28/11/22 another order, yet another order. So my lord, again my lord on 28/11/22 another
Yes.
order, yet another order.
Mr. Sharma, what do you say?
Oh, my lord, they are sleeping, my lord, over the mineral lethargy, and I am suffering, my lord. 14 months have gone. After my retirement, I am yet to receive my
See, the initial issue
Yes, sir.
which was raised by the petitioner has automatically resolved. Maybe there was an interim order of this court facilitating such resolution, but by effect of time, the matter has died away. There is no requirement for any adjudication. And she's been working. Now she's retired.
Yes.
Now where is the bar to consider her pension?
Till my retirement, my lord, I was given regular pay scale of a regular thing. I said it's a matter of record.
You
There will be-
facilitate this. Do whatever is required from your end.
So, my lord, they may submit a representation before the authority and also dispose the matter within 2 weeks, within 2 months, my lord.
They have undertaken that we will rectify, then here submitting that we go there and file a representation after all the series of orders by
See, from her retirement, more than a year has passed.
Yes.
I think 3/4/2022.
yes, my lord, 14 months.
14 months have passed. So at this stage, directing a retired employee to file a representation for consideration when this court is already in session of the matter, that is not called for. Will not pass this kind of order. There's nothing to adjudicate. It's directed.
Yes.
Heard AC Barbara Senate Council, assisted by Sri M. Smith for the petitioner. Also heard U. Sharma, Senate Standing Council, Secondary Education Department. Full stop. Considering the facts and circumstances and the development which has taken place in the meantime, comma, this petition is taken up for final decision. Full stop. This court has further been apprised that during the pendency of the petition, comma, the petitioner has retired
On 34,
from her service on 34/2022 and till date, the pensionary benefits have not been given to her.
Hmm?
Post-retirement post-retirement.
my lord, till 34 or till the date of my retirement, I was, my lord, given
We have
time scale.
We have said post-retirement. I'm not saying it post-retirement.
Otherwise, they will, my lord, calculate the pension, not on my lord regular time scale.
Not will
Not to make clarify.
will
Yeah.
The fact of the case was recorded in an order of this court dated 11/1/2019, and to avoid repetition, the state order is expected herein. 11/1. The senior counsel for the petitioner has submitted that there was no application for modification, alteration, or vacation of the interim order,
In fact,
and the petitioner continued to function as regular principal. Further, the incumbent against incumbent who was connected with the impugned order had also retired in the meantime, and the petitioner continued as the regular principal
and
of-
availed my lord regular fee.
of the college. The senior counsel has submitted that till our date of retirement on 30/4/2022, the petitioner was paid the regular scale of pay admissible to the principal,
To the regular pension.
to a regular principal.
Then my lord, 13
Para.
13/5
This
order,
matter
they intended
had come up thereafter on a number of occasions, and this court, in the order dated 13/5/2022,
Yes.
has recorded that the respondents were taking a rectification process, as in the meantime, the respondent number 5
retired.
had retired, and the petitioner was continuing in her service as the regular principal. The matter was thereafter listed on 3 more occasions, on which further time was taken by the department. The senior counsel has referred to the additional affidavit filed on 17/3/2023 and has submitted that though the petitioner had retired from her service on 30/4/2022, till date, no post-retirement benefits have been given to the petitioner.
My lord, the school authority has given an important certificate. It will be important, my lord, the next on page 57. That
Yes.
on the date of retirement,
The,
I had no financial liability.
Yes, the senior counsel also referred
Right.
to a no liability certificate, non-liability certificate, to a NOC/ non-liability certificate dated 13/2/2020, issued by the principal in charge of the school, certifying that the petitioner is released and the principal was free from all financial liability. It is submitted that though there may not be any further requirement to adjudicate the principal issue of this writ petition at the time of filing, in view of the developments, the connected issue of payment of post-retirement benefits is required to be directed, as the petitioner cannot be left high and dry after retirement. Sri U. Sharma, the counsel for the department, however, submits that the petitioner may file a representation which should be considered in accordance with law. So, but this court, after hearing the party, is of the opinion that in a matter pending since the year 2019, in which the principal issue has become almost odious, and the petitioner
There's been
has
number of-
also retired from service on more than a year back, directing consideration of representation that may not be in the interest of justice.
Moreover, in
on-
view of the series of orders,
Accordingly, this court, after taking into account the development, taking into account the facts and circumstances narrated above, and the developments which have taken place during the pendency of the writ petition, more particularly the fact of superannuation of the petitioner from service on 34/2022, and the grievance that no post-retirement benefits have been paid to her, this writ petition is disposed of by directing the whom
1 and 2, my lord,
respondent numbers
1 and 2.
directing the department as well as the directorate to immediately take up the issue to facilitate disbursement of the post-retirement benefit to the petitioner.
As a regular principle.
It is needless to state that such post-retirement benefits are to be reckoned by taking the petitioner to have retired as a regular principal, as she was given the regular pay, scale of pay till the date of her retirement. Full stop. The petitioner is may accordingly file, I am likely to submit a certified copy of this order to the concerned authority.
My lord, respondent 1 and 2, Dr. right.
Concerned authority, namely respondent numbers 1 and 2. And if any requirement, any requirement, any step are required to be taken by the petitioner, the same would be intimated to her within a period of 15 days from receipt of such. You need to forward the pension papers and all. You need to forward the pension papers, proposal, those things. That will be informed to you within 15 days from the date of receipt of the certified copy of this order.
Oh, along with the certified copy.
After fulfillment of such
No
requirements,
liability certificate, all this.
the matter relating to the pension of the petitioner be finalized within a period of 2 months from the state.
Real pension, my lord, right from. Nothing is not like it.
But we have given them some liberty that you give a certified copy. If there is anything required by you to do, they will intimate you within 15 days. You do that from that 2 months.
Certificate copy along with this no liability certificate and.
No, there will be some
service book.
there will be some format, everything you have to give.
I love the formal. Much obliged, lordship.
So Gogoi. Yes. Yes, what do you say? We have heard him.
Lordship,
We have heard him. What do you say?
Lordship, otherwise, my stand is that there's a appeal provision is there, Lordship, regarding order passed by the disciplinary authority, there's a appellate authority. Otherwise, also, Lordship, last occasion, as per my lord's direction, we are bringing a file an affidavit, Lordship, bring one document, Lordship, regarding whether petitioner has received that particular Lordship inquiry report or not. That part was Honorable Court directed that. As per per the records received from the Lordship.
No, that part Mr. Sharma has shown.
Lordship.
That envelope shows that he was not there
He
for
was
7
not
days.
there, Lordship. But
For 7 days.
7. We have sent it to his address which was given in the
That is okay.
Lord.
Now, there are two issues.
Lordship.
First issue is on the fairness of the inquiry
Lord.
proceeding.
Lord.
Okay, so as that whether the report by the finance,
Lord.
that internal committee report, fact finding,
Lord.
whether that was given to him.
Lord.
Apparently, it shows that it was not given.
Lord.
Whatever is there. Second is a more substantial question.
Lord.
That whether the report of the inquiry officer
Lord.
was given to him.
Lord.
He says that it was not given. You say that it was sent to him,
Just sent to
but
him.
the envelope has come back.
Lordship.
Thereafter, did you make any endeavor to serve the copy?
Regarding that part, Lordship, we have no any instruction. We have fairly submitted, Lordship. We have only
No,
sent
no,
it, Lordship.
that you,
And regarding Lordship, internal committee report, Lordship, it is not necessary to provide it because Lordship, on the basis of allegation, Lordship, some certain internal inquiries there, Lordship.
no,
And
see,
accordingly, Lordship,
your allegations
Yes.
are based upon an internal committee
that was
report.
Lordship, in the focus notice itself that was there, Lordship.
The allegations are based on a report. We are not asking you to give him an opportunity
Lordship.
in that fact finding report. That is a fact finding report. You can do it discreetly.
Lordship.
But once you rely upon such a report,
Lordship, that report is in my lord may kindly peruse page 48.
40,
Page 48,
we'll
Lordship.
come back.
Page 48, Lordship.
Yes.
It's a statement of allegation, Lordship, the list of documents, GP resolution dated so Lordship, and report of the Director of Financial Inspection Assam, that is there, Lord. It was given to him, Lord.
No, it was not given to him.
Lordship,
It is in the list of documents.
list of documents.
Then you see the next page.
Lordship.
He had asked for the documents.
Lord.
Did you give him the copies or did you allow him to inspect? Even if you say that documents we cannot give at this present stage, you should give him a chance to inspect the documents, make notes by pencil.
Lordship, page 50, Lordship, is fair, Lordship. Taking time
Page
to file.
49,
Page 50 also, my lord may look.
49 first page.
Page 49. With reference to subject cited above, I have the honor to request you to kindly to provide me the relevant document you have consulted before charging me with misappropriation of government fund, negligence of duty, and misuse of power, so that I prepare reply as so notice dated so and so, Lordship. My lord may then kindly come to page 50, Lordship. I have received so notice dated so and so, Lordship. Sir, at the first instance, I deeply apologize for not replying to the so notice dated so and so within the reasonable time. It is very unfortunate to state that due to an untoward incident, I was placed under suspension from service while I was working as a principal of Bilasipara College, Dhubri. Thereafter, due to such, I was not keeping well and therefore had no immediately rushed to Guwahati for taking recourse of the law for seeking justice. During the course of pending litigation before the Honorable High Court, I was mentally not in a position to submit reply right after receiving your focus notice, and in such circumstances was prevented from.
Was there any earlier litigation?
Lordship?
Was there any earlier litigation?
Lordship,
What had happened there?
Lordship, that litigation regarding suspension part he has come, Lordship, and he was as per Honorable Court, so that he was reinstated. He was transferred from Bilasipara College to other colleges for smooth functioning of that particular college. And presently one petition is also pending, Lordship, in respect of it due to non-granting of the pension and not updating the Lordship the service book by the Bilasipara College.
Let us read the impugned order
Lordship.
at page 52.
Lordship. Departmental proceeding was drawn against Dr. Malekuddin, regular principal of the Bilasipara College, now working as regular principal in Mondia Antolik College, where he was transferred upon approval of the government. He was suspended from so by this office letter dated so and accordingly, a focus notice was served upon him, along with statement of allegations by letter dated so. The following charges are came against the delinquent government servant, Lordship. That while he was working as principal Bilasipara College, he had misappropriated a huge amount for construction of women hostels in Bilasipara College. The matter inspected to the Directorate of Finance Inspection Assam. It was recommended by the DFI that excess expenditure of rupees 19,69,330 should be recovered from the salary of Dr. Malakuddin. Number 2, Lordship,
Hmm.
that while he was working as principal of Bilasipara College, he remained absent unauthorizedly from 18/10/2014 to 30/11/2014, and he did not hand over such an important document to the college like DB proceeding book, etc., to the president of the governing body of the college, which caused mass inconvenience to the college. Then Lordship, Sri Joyanto Thakuria, Deputy Director, Higher Education, Assam, was appointed as inquiry officer for the case of Dr. Malakuddin, was called for hearing in connection with the charge level against him on 7/2/7/2 Lordship, but he did not turn up and appeared for hearing, Lordship. The inquiry officer submitted a report of inquiry on 7/2 and same was sent to Dr. Malakuddin to comply the provision of Rule 9(2) of the Assam Service Discipline Appeal 1964. The report of inquiry was sent to the delinquent government servant through the in-charge principal of Bilasipara College for DTDC, receipt of DTDC Lordship. Then Lordship, the delinquent government servant was again reinserted as principal of Mondia College. By government approval letter dated 7/2 Lordship. I have perused the report of inquiry minutely. The inquiry officer in his report of inquiry states that he was convinced of the charge relating to misappropriation of government money to have been proved. The second charge relating to unauthorized absence to stands proved, and I was also perused the inspection note of the inspection carried out by the Directorate of Financial Inspection Assam. The inspection report forms the part of the record. Then Lordship, it is reported that Dr. Malakuddin, the then principal of Bilasipara College, engaged labor purchase materials for construction of women hostels of Bilasipara College without any consultation with the members of the construction committee of the college. That the Directorate of Financial Inspection recorded Dr. Malakuddin, the then principal of the Bilasipara College, spent an excess amount of rupees so Lordship only without any justified work. The Directorate of Financial Inspection recommended the recovery of the amount from the salary of the delinquent government servant. Then next page, Lordship. Having agreed with the report of inquiry, I am convinced that the delinquent government servant was afforded enough opportunity of defend himself. Written so-cause notice was served against the delinquent government servant. The so-cause notice was accompanied with the defined statement of allegation, which is in file on so-and-so of this office. Having agreed with the report of inquiry, I do hereby inflict the following punishment under Rule 7 of Assam Service Discipline Appeals Rule 1964 on the group servant. I am convinced that the act of delinquent government servant is responsible for pecuniary loss to the state gov. I do order that the entire amount of rupees 19,69,330 be recovered from the delinquent government servant. The recovery will spread over a period of 48 months starting from January 2018 and ending in the month of December 2021. His date of retirement being the month of March 2022. He draws a gross salary, monthly salary of rupees 1,46,000 approximately. The monthly recovery would be rupees 41,027 and 70 paisa only per month. The recovery will start from the 1st January 2018. The head of account to which the recovered amount is to be deposited will be communicated separately. The president of the governing body of the Mondia College will ensure recording of this order in the service book in the delinquent government servant. With this, the departmental proceeding drawn against the delinquent government servant Dr. Malakuddin is hereby concluded. Here, Lordship, after perusing the report, it says that Lordship was called for before the Lordship inquiry committee, Lordship. He occasions, Lordship, and he was not turned up before the inquiry committee also, Lordship. And regarding, Lordship, the supply of the report of the inquiry committee, Lordship, that was an admitted fact that, Lordship, it was returned back by the DTDC courier due to non-availability of that Dr. Uddin there, Lordship. And otherwise, Lordship, our submission is that it is an appealable order, Lordship. We can prepare appeal, Lordship, under the Assam Service and Discipline Appeal Rules against the order of any punishment. And if otherwise, Lordship also hold that Lordship, the inquiry not conducted, the procedures to be followed, the inquiry was not followed by the authority. Then also, Lordship, it is guided by the Honorable Apex Court judgment from the State Lordship when
But one more, that is a recourse which is available to us.
Lordship,
One more aspect would still remain,
Lordship,
that at the initial stage, when the show cause notice was issued,
Lord.
based on the report of the DFI,
Lord.
that report copy was not given to him, so that he
Lordship,
could have given
but
an
Lordship, the
effective.
representation which he was given later on, Lordship, he does not, Lordship, reflected regarding the page 50, Lordship.
That is a
Page
different.
50, Lordship, he says that only due to his illness and other mental condition, he is not able to, Lordship, reply the same, Lord.
But we have to.
But Lordship, he is not turn up to the inquiry commission.
That we are not giving him any benefit.
Lord,
But the consequence of the report,
Lord.
before accepting the report, his views are to be taken.
Lordship, that part, Lordship, we have to, Lordship, he have to appear before the inquiry committee. Then, Lordship, he can also argue that part also, Lord.
No.
And otherwise,
Suppose one officer voluntarily,
Lord.
he doesn't appear before the committee. The committee takes an expert view.
Lord.
He cannot raise an issue that I was not heard by the committee,
that cannot be, Lord.
by inquiry report.
Lord.
But he is still entitled to the report.
Lord.
Because before the report is taken into consideration by the DA,
Lord.
disciplinary authority, his views are to be taken.
Lord.
If the findings are against him, if the findings are in his favor,
Lordship, Lord.
matter ends there.
Lord.
Then also the disciplinary authority can take another view,
Lord.
but then also he has to give a notice.
Lord.
Notice upon the incumbent is mandatory.
Lordship, Lord. That part, Lordship, is otherwise, Lordship, my explain is that, Lordship. It is an appealable order. He can take this down before the appellate authority, Lordship. And alternatively, Lordship, as per the Apex Court, Lordship, the law laid down by the
You have submitted it very fairly that we have taken note. But the only difficulty is this order of penalty
Lordship.
is of the year what 2017.
2017, Lordship. Lordship.
Now
Now appeal is, Lordship.
that will not be proper.
Now I also not
That will
include
not be in the.
I also not
Yes,
insist that part.
anything.
Otherwise, it is a Lordship, it is an admitted fact that there is a financial irregularities is there, Lordship.
No, we rest assured we are not going to say anything on the merits of the case.
Lordship, Lord.
The allegations
Only-
are very serious.
Lordship, Lord.
90 lakhs of public
Even
money.
single paisa of the public sector also, Lordship.
Yes, Mr. Das.
My lord, one thing I just want to point. This is the second aspect of the matter where Lordship inquiry report I have excited. So that, but very important, which your Lordship said now, because your Lordship has not gone to this rule. I'm saying
Rule.
rule is very important. Kindly see this rule. I always bring a second book. So, like Assam Financial.
Gogoi doesn't need a book. Everything he remembered.
I don't remember. He's good. He fights for the case. Assam Financial Inspection of Department Sanction Lordship.
Which rules are you?
This is Assam Financial Inspection Department Sanction and Implementation of Scheme Rules, 1982, under which the inquiry was conducted. Assam Financial Inspection of Departmental Sanction. You know, holding this local act. Local act.
Where with the service code.
No, local act. Local act is required. That's why we have given an extra copy. Local act.
We should have finance.
Assam Financial Inspection of Departmental Sanction. Volume 8. Volume 8. Page 371. very important, my lord, here. Lordship got it? Kindly see B. Director
Yes, please.
PB to PB. PB. Director means the Director of Financial Inspection Assam and shall include additional director, joint director, or deputy director of financial inspection appointed by government from time to time. Got it? One particular, again, one definition is important. L. Executive agency means the contractor or the person / person entrusted with the execution of the work.
Yes.
Here the principal was entrusted with the execution of the Gulf hostel. Now kindly see 4. Control over director. 4. The director shall work under the administrative control and supervision of Secretary Finance. Secretary Finance shall issue such function and working of director. Works of admin department concern as may be found necessary appropriate so and so. Decision of the Secretary Finance will finding and so what is the duties under 5. Now kindly see 7. Rule 7. The director, after having complete check and inspection referred to in Rule 5A, above shall submit a report to the Secretary Finance Department clearly bringing out all cases and nature of financial irregularity detected by him in the course of scrutiny of relevant papers, documents, etc. produced during check, inspection, and the Secretary Finance Department shall thereupon proceed with the report in such a manner as may be deemed necessary in the interest of financial discipline economy. Provided director before submitting his report to the Secretary Finance communicating any lapse or irregularity found at the stage of inspection shall formally communicate to the executive agency his findings so as to give them an opportunity to explain the lapse or irregularity. Where is that? This is why, my lord, there was a stay which was granted by the court. But if this is was been given to us, if you would have given a reply, if you would have been satisfied, then there was no occasion of issuing a so cause notice. So cause notice is based on this report. So cause notice is, my lord, based on this report. And this we once we got it, my lord will kindly the sequence. My lord, when we asked for producing some documents to us, on that day itself, they said, no, we are not giving you time. This is the order of the authority concerned. Kindly see at page 52, my lord.
Yes.
My lord will kindly see at page 47. This is a so-called notice, my lord, on 27/3. Kindly see 1. 27/3/2017. Kindly see *1.
Yes.
It was that while you are working as principal Bilasepara College, you have misappropriated a huge amount for construction women hostel at Bilasepara College. Matter was inspected by Director of Financial Inspection Assam. It was recommended by DFI that excess expenditure of 19,69,330 should be recovered from the salary of Dr. Malikuddin, principal, under suspense for Bilasepara College. Bilasipara, you are therefore charged misappropriation. So, my lord, the provisions are very clear. So, we went to them, statement of allegation at page 49, where your lordship has looked into it. With reference, I have the honor request to kindly provide me with the relevant documents you have consulted before charging me misappropriation government fund, negligence of duty, misuse of power, so that I may prepare reply to so cause notice. Now again at page 50 on 14/12, we have again asked to file reply to so cause notice, and this is 14/12. When we went to the office at page 52 on 13/12/2017, they have handed this order. And what is this order? Kindly see, my lord. At 1:1, that while he was working as principal, he has misappropriated a huge amount of construction of women's hostel the matter was inspected through the Director of Finance Inspection. It was recommended by DFA that excess expenditure of 19 lakhs should be recovered from the salary of so. So, where is the opportunity you have given under this rule? When this report was submitted, before submitting the report, at least that report should have been furnished to me as per the rule. I could have given a reply. Maybe you may reject my reply. Absolutely no problem. Then you could have ordered. Then so was notice saying that no, we are not satisfied. We are not satisfied. We are satisfied with the report. Where is that by? Your lordship was asking that no opportunity is given because this is the rule what is said by. One is the inquiry report is not been heard. That's number one. That's number two. Number one is the inquiry which they have conducted. Procedure has been laid down. They have violated it. They have not given any report to me, to my lord, to justify that.
You have the inquiry report.
Today I have not the record.
You have the copy of inquiry report now.
Inquiry report is DFI, my lord.
No, not the now the inquiry by
Inquiry report, no.
unofficially you have
No. DFI report I have got.
DFI you have an extra.
Yes. We came to know only when inquiry report today also we have.
Latest factor law he is not received the inquiry report.
DFI.
Inquiry report.
Second one.
Second one.
No, even the first one.
First one also
Senior counsel
Lordship,
is submitting that there is a statutory provision
Lord.
to provide him a copy of the report,
Lordship,
an opportunity for submission of the
Lord.
report. If there is a statutory provision, we want to see from the inquiry report in the disciplinary proceeding whether the inquiry officer had applied some independent mind or straight away taken the report of the DFI.
Right.
That will also be very material.
correct, Lord.
See, if he had again tried his mind on the veracity of the DFI, then matter would be slightly different. But he was straight away, he has picked up the report,
Right.
wherein it was prepared without giving him an opportunity. That will not be proper.
Then
That will
Lordship-
not be legal.
Then Lordship, I have nothing to otherwise. Lordship, on the basis of that judgment, Lord. Lordship, that order may discussion be closed.
No,
Lordship,
no,
2018 matter.
Remanding the matter to for a fresh adjudication normally is there, but here he is also hitting the root. Root starts from the DFI report.
Lordship,
Which-
I have no objection. If the status starts from that,
Which one?
from DFI report, Lord. Finance report, if as per petitioner, Lord. Yes,
That you are at liberty to, but you cannot only because you are holding an inquiry, you cannot stop the pensionary benefit.
pensionary benefit, Lordship, we cannot stop, Lordship.
No, it's not.
That has been stopped.
Pensionary benefit on that particular petition, pensionary benefit was not stopped. Pensionary benefit stopped, Lordship, his challenge under petition only because of that, Lordship, his particular service book was not updated by the concerned college, Lord.
Oh,
That is the
that's
reason, Lord.
So that is over. I think my learned friend, I have done those cases.
That is the
That
reason.
case is over. They have already, the service book has been updated. There is absolutely no problem.
Regarding that pensionary benefit, we are not held up, Lordship. Regarding this particular issue.
If, my lord, I am only what I am on my pensionary benefit. I am not getting a single penny because of all this. Let them
Lordship,
clarify. Let
Lordship,
them clarify that my pensionary benefit will not be withdrawn because of this, what they are doing.
Lordship,
I am not getting it, my lord. It's a principal retired. See, I have to look after my families also.
regarding that part, Lordship, I have nothing to say. Regarding inquiry part, Lordship,
But first allegation,
First allegation about 19 lakhs. No, that's definitely my.
that's also
That
not a
was
very
given a chance.
Lordship.
simple allegation.
No, that was given a chance to me, my lord. I said to him,
Is there a
said,
hostel constructed?
the
Actually?
hostel construction is constructed.
Was it
I
was
don't
it
know.
was
He
it
said
cons-
he's
was it constructed?
No, that's a, my lord, I'll say, my lord, but that's a very serious allegation. It's a money. It's not your money. It's a government money, public money.
Then,
You
Lordship,
cannot
19
misuse
lakh.
it.
it's about girls hostel, Lordship.
No, I know. But there was a lot of problems in that college. I was
Girls
not,
hostel will make a difference, not a boys hostel.
Girls
my
hostel,
lord,
Lordship.
lordship, why I've been placed under suspension? Bilasi Para governing body was not allowing. My service book also not released. In spite of an order, I filed suspension order was challenged. While I was reinstated, government went for an appeal against the suspension order. against a
So
single
we
withdrawal.
are proposing to do one thing. We'll allow this petition. We'll give you liberty, but
Sure.
not from the these days of inquiry report.
Sure.
We'll touch upon the DFI report.
Lordship, Lordship.
Thereafter, if law permits you, we can. But this proceeding shall not be
Power to
Uh,
release the pension.
yes,
Yes,
it will not be
definitely I want.
it not be connected.
Lordship,
My whatever may be
pensionary benefit
convicted,
cannot
my
restore.
pensionary
Cannot-
benefit.
If Lordship, after that disciplinary proceeding is over, Lordship, as per law, if you cannot recover from the pension
Yes,
amount,
sir,
also,
suffer from my pensionary, from my pension.
When did you retire?
I retired 2021. 21. I have one son, one daughter, my son. Very difficult to manage. Not a single penny. And I know your lordship is in I have understood. I have understood.
his
You-
salary
Once
Lordship
my-
not
I
invested
don't
in the
think you
bank
require
Lordship.
pension
Bank of deposit card আছে।
of the record. Mr. Gogol,
Lordship,
of the record, I don't think he requires pension.
Lordship. Lordship. Otherwise also Lordship, he is not deposited a single penny in the bank account during the service time. So Lordship,
Where?
petitioner Lordship, now he is facing Lordship.
No, he is not deposit. He is not money was not coming to it.
He did not deposit where?
Last time,
All money when I joined Mondia College. Bilasipara, I was, government has given to join Bilasipara. Governing body has done all this. This is the whole problem, man.
He does represent a council assisted by CK Mohammed for the petition. Also heard. He with pending on higher education department. Considering the subject matter in dispute and as agreed to by the party, the this writ petition is taken up for at the end. Para. The petitioner has put to challenge a report number 13 of 2016-17 prepared, submitted by the Director of Financial Inspection from Assam, a proceeding initiated, a disciplinary proceeding initiated by so-called notice dated 27/3/2017, which had culminated, which had culminated in an order dated 13/12/2017, by which a penalty for recovery of an amount of $19,69,330 has been directed. Para. The petitioner was serving as the principal of Bilasipara College when an order dated 23/6/2016 was passed, placing him under suspension on certain allegations. The the aforesaid suspension was, however, the subject matter of a litigation, subsequent to which, though the petitioner was reinstated, he was transferred and posted to the Mondia College, Mondia Anchalik College, in the district of Borpeta. Para. With regard to the disciplinary proceeding, comma, it is the projected case that an inquiry was initially conducted through the Director of Financial Inspection, Assam, who has submitted a report being report number 13 of 2016-17. In the same report, comma, a finding was arrived at that the petitioner had misappropriated that the petitioner had made payment of excess amount of rupees 19,69,330 without any justified work, and therefore the said amount was recommended to be recovered from the petitioner. The petitioner submits that such inquiry was discreetly done and the report submitted without giving any opportunity to the petitioner. Thereafter, comma, the petition, thereafter, comma, a so-called notice was dated, so-called notice dated 27/3/2017 was served upon the petitioner, mainly on two allegations. The first allegation was in connection with the report of the DFI on excess expenditure of rupees 19,69,330, where there was a recommendation for recovery from the petition. The second allegation, which has been divided into two parts, three allegations. The second allegation is with regard to unauthorized absence from 18/10/2014 to 13/11/2014. Third allegation is connected with the second allegation, whereby it has been alleged that during the same period from 18/10/2014 to 13/11/2014, comma, the petitioner did not hand over charge and important documents to the president of the governing body of the college, which has caused inconvenience. Full stop. The so-called notice was accompanied by a statement of allegation, which contains a list of witnesses and a list of documents. Full stop. In the list of documents, comma, the report of the director, comma, financial inspection, Assam, was indicated. On receipt of such notice, comma, the petitioner had submitted an application dated 19/4/2017 whereby a request was made to provide the petition with the relevant documents which were the basis of the charges. The petitioner, they said the request was followed by another request dated 14/12/2017. They submitted that in spite of such request, no copies of the documents on the basis of which the allegations were made were handed over to the petitioner. Neither he was given any scope to inspect the same. Full stop. The petitioner submits that he was not aware of any ensuing inquiry, but was surprised to be informed. Surprised on getting the information that an order was issued by the Director of Higher Education on 13/12/2017, whereby the petitioner was imposed a penalty for recovery of an amount of rupees 19,69,330, which was divided into parts within to be recovered within the span of time from January 18 to December 2021. Full stop. The petitioner submits that immediately on coming to know of such inquiry report, he had submitted an application for grant of some more time to file his defense statement, which, however, was rejected by a communication dated 27/12/27. The draft the London Senior Council for the petitioner submits that the inception of the proceedings, namely the report of the DFI, is itself not legally sustainable and legally sustainable. He further submits that apart from the ground of challenge, which would be elaborated subsequently in this judgment, on the ground, on the opposite ground itself, that the report of the DFI is not sustainable, the entire department is liable to be interfered with. In support of his submission, the Learned Senior Council for the petition has referred to the Assam Financial Inspection of Departmental Sanction and Implementation of Scheme Rule, 1980. The definition of director and executive authority appearing in section 3 (b) and 3L, allowing the control over the director appearing section 4 have been pressed to service. Full stop. Emphasis has been laid on section 7, which based on the procedure for submission of a report. Full stop. He submits that the proviso to the state section makes it clear that before the director submits his report, comma, there is a requirement to formally communicate to the executive agency his findings so as to give them an opportunity to explain such lapse of or irregularity. Para. For a reference, comma, he it is submitted that it is an admitted case that the inspection was done in a discreet manner without taking into confidence, no, without taking, without in absence of the petitioner and without giving him any opportunity before the report was furnished. Full stop. Para. The senior counsel submits that without prejudice to his contention that on the aforesaid basis the consequential action is not sustainable, comma, it is submitted that even the consequential actions are in violation of the established principles of law governing the field of disciplinary proceedings. Full stop. By drawing the attention of this court to the so-called notice dated 27/3/2017, comma, it is submitted that to give an effective opportunity to give a reasonable opportunity to make an effective statement of defense, comma, the materials which are relied upon for framing the charges are required to be given to a delinquent, or at least inspection of such documents are required to be given, which admittedly has not been done. Full stop. He further submits that the inquiry was conducted expertly and the petitioner was not informed about such an inquiry. Full stop. He such inquiry until date, comma, the report of such inquiry has not been furnished to him. Full stop. Para. The senior counsel submits that the requirement of law does not end at the stage of inquiry, and there is a further requirement of giving an opportunity to the delinquent by the disciplinary authority before acceptance of findings of the inquiry report which are adverse to him. Full stop. In the instant case, comma, no second so-called notice was given to the petition, and therefore the petitioner was deprived of a reasonable opportunity to present his case and defend himself. But, the senior counsel accordingly submits that the entire action of the respondent authority are being not sustainable in law are liable to be interfered by the truth of. This court has further been informed that in the meantime, informed that though there is an interim order by which the recovery directed has been stopped, has been stayed, no pensionary benefits have been no post-retirement benefit has been benefit have been given to the petitioner. In spite of the petitioner who had retired during the pendency of this case on 31/3/2022. In March 2022. Yes. In March 2022. Full stop. It is accordingly submitted that while interfering with matter, a consequence direction to clarifying that the post-retirement benefit cannot be withheld and connected with the present profit, which is referred interfered. Per contrast, Rishi Gogoi, Senate Counsel for the department, has submitted that the allegation, more particular, the allegation number 1 is of very serious nature, as it involves a huge amount of public money. Full stop. He submits that the amount was sanctioned for a girls' hostel in the Bilasipara College, which apparently was misused, as per the report of the DFI. As regards the challenge to the report of the DFI, the Senate Council submits that the aforesaid report was not acted unilaterally, and the views of the petitioner was sought for, which could be evident from the show cause notice dated 27/3/2007, and therefore the application of the proviso to section 7 of the rules of 1980 may not come into the way. So, as regards the allegation that the inquiry was conducted ex parte, he submits that on each occasion the petitioner was informed regarding the sitting of the inquiry, and he, on his own volition, had declined from attending the same. Sri Gogoi has also referred to the representation of the petitioner on petitioner dated 14/12/2017, which would rather reflect that the petitioner had almost admitted the allegation. No. Uh, which would reflect that not reflect that the petitioner was had taken some other ground for not being able to submit a so-called notice. Full stop. He further submit that with regard to the allegation that the report of the inquiry officer was not furnished to the petitioner, comma, Sri Gogoi submit that the report was in fact issued to the petitioner by DTDC courier on DTDC courier, which however had returned with the remark out of station for 7 days, and RETD returned RETD to sender as the 14th of last the Senate Council accordingly submit
It is registered. Registered.
not DTDC,
Registered.
DTDC courier only.
Registered post office. We have annexed a copy.
Or the DTDC as well as by registered. As well as by registered. He submits that the petitioner was aware. He submits that it can be deemed that the petitioner was aware of the report and had and on his own volition did not offer his comments to the inquiry report. He accordingly submits that no fault can be attributed to the director in passing the impugned order dated 13/12/2007, which has been done by taking into consideration all the relevant factors. Full stop. Para. The alternatively, the Senate Council submit that even in the event this court comes to a finding that the order dated 13/12/2017 was issued, was passed without taking the views of the petitioner, the matter may be remanded back from the stage of giving the petitioner an opportunity and passing an order after considering his comments on the inquiry report. Sri Das, the Senate Council, however, submit that mere issuance of the statement made that the copy of the inquiry report was issued to the petitioner by post cannot mean that the report was received by the petitioner in absence of any substantial evidence. Full stop. He further submits that the petitioner was posted and working as the principal of Mondia College, Borpeta, where the report could have been easily issued and the documents annexed by the respondent in the affidavit, in the additional affidavit dated 22/5/2023 would show that such letters were posted to in the name of the petitioner at his Kokrajhar and at his residential address at Kokrajhar and college address at Bilaspur. In any case, it is submitted on behalf of the petitioner that the statutory provision contained the rules of 1982 cannot be ignored, and the report of the DFI itself is liable to be declared as non-estate law. This court has carefully considered the rival submission made by the learned counsel for department and have perused the materials on record. In an ordinary case, ordinary case, this court would be loath to interfere with a fact-finding inquiry on the ground that it was discreetly done without giving an opportunity to a delinquent. However, there is a distinction. There is a marked distinction in this case where such fact-finding inquiry is governed by a statutory rule, namely the rules of 19. The proviso to Rule 7 clearly states that there is a requirement to furnish, to give the executive agency an opportunity to explain any lapse or irregularity in relation to which an inquiry was conducted before submitting his report to the second. For any the relevant part of Rule 7, which the proviso is expected here in below. The Standing Council finally submits that there is a provision for appeal in the rules governing the parties, namely the Assam Disciplinary Appeal Rules of 1964, regulation of 1964, and without exhausting the state remedy, district petitioner. And put for it. The aforesaid provision is clear that it is mandatory, that in the opinion of this court, the requirement of furnishing a copy, requirement of giving an opportunity to the incumbent before submission of the report is a mandatory requirement, which is also in consonance with giving a fair and reasonable opportunity to a person against whom certain adverse report is to be submitted. Apart from the same being a part of the principles of natural justice, not granting such opportunity would also be in violation of the doctrine of reasonability, which is the hallmark of Article 14 of the Constitution of India. Since this court has come to a finding that the basis of the departmental proceeding, which is the report of the DFI, is itself without itself not unsustainable in law, there is actually no requirement to examine the validity of the process adopted by the authorities in the disciplinary proceeding. However, in the interest of justice, this court has also noticed that the disciplinary authority also suffers from numerous infirmities in law, making the same fully unsustainable. Firstly, the delinquent against which a proceeding is initiated is required to be furnished with copies of the documents based upon which the allegations have been made. Even if in a given case, such documents are not able to be furnished, the delinquent is entitled to get an opportunity of inspection of such documents and to make notes, which apparently has not been done in the instant case, in spite of requests made by the delinquent, as could be evident from the representation submitted immediately on receipt, representation dated 19/4/2017, submitted immediately on receipt of the so-called notice. Full stop. The inquiry report has not been made a part of the process, even by the respondents. However, from the submissions made and on reading of the penalty order dated 13/12/2017, it appears that the inquiry was, and the sittings of the inquiry were held on 3 days, namely 28/6/2017, 7/7/2017, and 14/7/2017, and in none of the days the petitioner was present. Even if the version given by the respondent that the petitioner opted not to appear before the inquiry officer is accepted for the sake of argument, comma, it cannot be. It is not in dispute that ultimately the inquiry was done expertly the petition. Full stop. That apart, comma, there is nothing on record to show that the report of the inquiry officer was served upon the petitioner before the same was acted upon by the disciplinary authority. Full stop. It is the settled position of law that before the disciplinary authority takes into account the findings of an inquiry report, comma, the comments of the delinquent are liable to be considered so that a reasonable opportunity is granted to the delinquent to convince the disciplinary authority to take a view against any findings which are against the delinquent, and the said opportunity, which is of immense importance, has not been given. Full stop. That the Honorable Supreme Court in the landmark case of MDECIR versus B. Karunakar reported in 1994, 666, 737, 737, and 797 has laid down as follows, paragraph 20. The Learned Standing Council may be right contending that the rules, that the regulation contain a provision for referring an appeal. Full stop. However, comma, considering that the impugned order of penalty is of the year 2017 and this writ petition is pending since the year 2018, comma, remanding the petitioner to the appellate authority would be of no purpose, more so when appeal lies for whom?
Commissioner Secretary. But the disciplinary director also is right.
More so when both the appellate authority and the disciplinary authority are defended by the departmental counsel. Full stop. Sarah, in view of the aforesaid facts and circumstances. No, while this court has come to a finding that the impugned action of the respondent is not sustainable in law, comma, the seriousness of the allegation, more particularly the first allegation, wherein public money is involved, cannot be overlooked. That in view of the efforts and facts and circumstances of this court is the circumstance, this writ petition is allowed and the impute report of the DFI number so and so, comma, inquiry report submitted on 29/8/2017 and the penalty order dated 13/12/2017 passed by the Director of Higher Education are set aside. It is, however, made clear that considering the seriousness of the first allegation, the respondent would, however, would be at liberty to initiate an inquiry, which, however, is required to be done strictly in accordance with law, if so advised. It is further made clear, in view of the submissions made that the petitioner's pension has been held up, it is made clear that such pension, such action of holding up the pension cannot be related to the present proceeding and the pension and the post-return pension, and the post-return benefits are required to be released to the petitioner expeditious, if not unless there is any other legal objection.
Let me also indicate that lordship, the outcome of the lordship, the proposed inquiry, lordship, it will depend upon the outcome of the proposed inquiry. Regarding,
It is up to you to initiate.
now we will initiate, lordship. Lordship may indicate that regarding that recovery part will be there in future, lordship, if it initiated. Recovery part, if initiated there, if proof the allegation. They can anytime they can come up with a
You can from the pension also you can. We have given the liberty.
Lordship may indicate that, lordship.
See, you are taking action. Whether that action is justified or not, we do not know.
Lordship.
That may again come up to the court. You do in accordance with law, there will be no restriction.
Outer limit of pension that can be given.
Which one?
Limit pension.
will see.
Here the issue is not a pension here, lord. Pension
We have
matter is-
clarified.
pension
Unless there
matter
is
is
legal
already
sub-
pending, lord.
others we will not be able to take up. There is some meeting. Any case where interim order is there, Mr. Chaudhary, your sitting is wrong. Mr. Das should be penalized for making you sit. Other side,
The other side matter will be mentioned by order because there is no issue.
madam, you are there on the other side. Who's there?
Nobody is here.
No, who has mentioned this?
I am for the petition.
The petitioner. You had mentioned it. You had, the matter has been listed on
by
the
order.
basis of a mention memo.
Yes, my lord.
What is the urgency?
My lord, my side will argue in this matter.
What is the urgency? Are you aware of the urgency? The matter involved.
Sir, relating
My
to the appointment of the
my appointment as principal has been given. There is no issue.
You will have it some other day.
Yeah.
He'll give you a date. Any matter where interim order is still today. Huh? No, he'll give date. Interim order till today, any matter. Mrs. Sahu, which matter?
My lord, parallel case has last 2013.
13.
I have filed the review petition. So
13 review. Today we could have done it, but today we have to write.
after
Wait, tomorrow,
they have to
tomorrow, I would report.
34.
Who is for the other side? We'll have it tomorrow. 13 review. What is the review?
Lordship,
Sharma for whom?
Lordship.
You for whom?
I am for the in the writ petition. I was in a writ petition.
You for the petition.
Yes, Lordship.
And
It goes in my
Sahu-
favor,
Sahu for whom?
and he is for Numaligarh Refinery.
Refinery has filed a review.
Lordship.
For what?
For reviewing of this judgment and order passed by the
Understood. For what review? What is the review? What is the direction?
Here is central excise.
Central excise.
I will show Lordship tomorrow. Most probably review will not lie in this case. He should have prepared an appeal. But even then, Lordship.
Tomorrow.
Lordship,
He comes from outstation, so we'll have it tomorrow.
Lordship.
Possibility of time did not this tomorrow. Did not time. Since this review is pending the year 2013, this court consideration mode. Tomorrow you make a mention, we'll upgrade the map.
Lordship.
16. Not 13, Mr. Sahu 16 review. 2016.
2016,
10 case is 2010. There are success in 2016.
2016 review.
Offer repetition of 2010.
Lord.
Have it tomorrow. You make a mention, we'll accommodate you.
Yes.
During the course of
Lordship, I number 39, 19 Lord. We are not right now engaged council Lord. I have to on behalf of M1 Lord. First Lordship,
You want time?
no Lordship. We have done the file for the petition Lord. But we have another engaged advocate engaged Lordship.
Who has been engaged? Any idea who has been engaged now?
I'm not right now. I don't know Lord.
What is your name?
Take that on behalf of M1 Lord.
Item number?
19.
It is this court has been informed that Sri M. Khan and his associates are no longer the counsel for the petition, as the brief has been ended, as the brief has been taken away, and some new counsel have been engaged. Post of that, list of the two, registry may verify and reflect the name of the new counsel, if any.